I guessed it last week
How did you know?
because I've been reading all this stuff about delineation of lots and parcels and all this nonsense, and they said the only true way is to delineate with a road. And I said, that's why they need that road. They need to move the road so they can hook up and make an A&R so they can get a bigger person. That was my guess last week, and then I
We're good
saw.
to go. We're live.
It's not with us.
We're
It's
on.
not,
Okay.
We're
I
on.
mean, there's this thing
Are
really.
you ready?
Yeah.
Good evening, it's Monday, February 27th. This is the meeting of the Southborough Planning Board. The planning board is now in session. Oh, did you miss that? Yes.
Oh, it was perfect this time. Good evening. It's Monday, February 27th, 2023, and this is a meeting of the Southborough Planning Board. The planning board is now in session. The first item on the agenda is a discussion item on the planning board contingency and the memorandum of understanding between St. Mark's School and the town in the road discontinuance, and town council is here. Good evening, Jay. Thanks for being here.
Good evening.
Can you hear us?
He can hear us. Can you hear? Can you hear?
Can you
him?
hear me?
I can't hear him.
I'm not on mute.
Should he be coming over the speakers from? We can't hear you, Jay, so we're trying to fix that.
Yeah,
I can hear him on my ear. No, we're going through the sand system here.
okay.
Does Terry know?
You can hear us.
Is that bad? Something. Hold on. Can you hear me?
I think I'm on the, hold on a second here. Let's see.
I'm supposed to say unmuted.
You're only picking up us?
Well, he's not talking.
Jake, can you say a few things? Maybe count. Oh, it's because we- Jake, can you say a few things? See if we can work on this?
Sure. I don't know if you can hear me now or not.
No, you guys can't hear.
Unplug you. What if we unplug you? How about now, Jay?
This is Bridget. Jay is audible to the public.
Jake, can you say a few things? See if we can work on this?
Test.
Oh,
Test.
there he is. That's my
Can
plan.
hear me?
All right, now, that was my YouTube delayed.
So now? Can you hear Jay?
I think we can share, Jay, if I put my microphone here. All right, say something, Jay.
Just remember when you're talking, your mic is on when you're talking.
He almost looks like he's,
We can't hear Jay yet, can we?
I don't know, he looks like he's frozen now.
No, he's blinking.
Oh.
Oh, boy.
Can you ask him? Jay, can you hear us?
I can hear you.
Yeah, we can hear
Oh,
you now.
now we can hear you. All right.
It's coming through. Yeah.
Is that okay?
Yeah.
It's echoing down.
Does anybody else have, everybody else is off?
Yeah.
Well, I was gonna,
I was going to talk. So we have two things on the, for this discussion item, and I thought we'd start with the MOU first. It is.
Sure.
Jay, check. I can just see if you want to you until this.
Okay. So I guess I'll start. The first question is, the planning board contingency,
Right,
why that's there.
because St. Mark's wanted it
And,
there.
well,
It wasn't
start with
my
that.
inclusion.
He was talking when you were talking.
Oh. I
Say that
didn't hear.
again, Jay, we didn't hear you.
St. Mark's asked that that provision be in there. I didn't see the need for it, but they wanted to make sure that if they need an approval, and Karina has told me that it's her understanding based on the read of the site plan procedures that they will need some kind of approval, that they wanted to make sure that was a contingency. i.e. if they don't get the approval for what they want to do, which seems unlikely, then the any transaction with them would be off. Pretty straightforward.
Okay.
How far
My second question then is, that St. Mark's has committed to site plan review
Back here.
in previous,
I don't know what they've committed to.
we have an email, Karina had asked them.
Okay, I mean, that's fine with me. If they, if they're going through the process and under the Dover Amendment, if there's a process that actually applies, they have to go through it at least nominally. So I wasn't aware that they had contacted Karina, but that's good.
So then can we take that sentence out of there?
No, because they may not get approval.
No, the additional sentence that says, the school shall apply for any required planning board or other municipal approval, or alternatively provide notice that such an approval is not required.
It seems relatively harmless that it remain in there. I don't know what the status of the execution of the MOU is right now, if it's been executed or not executed, but I suppose they could always withdraw and then resubmit. It seems basically harmless to me that even if they've already applied, which I don't know if they have or not, that that language stay in there.
So my opinion is that it's not harmless because this
Well, have they applied?
project has been very controversial, and I think that just adds to the questions around this.
Well, if
so
they
when
have
is
to
the-
apply, though, I'm not sure I understand if they have to apply and it's important for them as a contingency and they haven't applied yet, that language seems appropriate.
What I'm talking about is provide notice that such an approval is not required.
Well, it arguably isn't required, depending upon what they're doing and given the strength of the Dover Amendment. But I don't think they have a problem applying. So that's what I believe they're going to do. I don't think they're going to waive their rights to claim that they're exempt from some level of approval because of the Dover Amendment. They're an educational institution, so they have that right.
They have that right, but previous legal opinion from you said that under Dover, they're still required to, not St. Mark's in particular, but in another circumstance, they're still required to apply for site plan, but certain things we can't regulate.
I totally agree with that. And I haven't changed that one bit. I just don't know the four corners of exactly what they may apply for and the timing of that and how that's going to be interpreted. I'm not trying to put words in their mouth. This wasn't my request. that to me, they could have kept this entirely separate. They're the ones that wanted the contingency in. I didn't see it as having an impact to the overall understanding of the parties in terms of the conveyance of the two properties. It seemed relatively mechanical to me.
My other question is that under the town meeting contingency, if approval isn't obtained, this agreement, this MOU, shall be null and void without any force and effect, provided however that such failure to obtain approval subject to the applicable provisions of section 5, which is the license here.
Which
But
has
the
been
planning
really
board-
watered down quite a bit, I believe.
Right, but the planning board contingency still says shall not affect the validity and enforceability of the license terms contained herein.
Right. I think the license now is, originally the agreement had a much more robust set of license provisions. Now, the only remaining license provisions, based on my recollection from the last version, is relates to the restoration of property that's already been altered a little bit during the early phases of the project.
All right, Mr. Stein?
Jay, can you hear me?
I can.
Mind if we just back up a second?
Sure.
So back to what Mimi was just asking about. If for some reason town meeting does not approve this transaction, then what exactly is null and void?
The deal, the project, all of
The
it.
whole thing.
I mean, there are other means of potentially of accomplishing the project, but the project in its current vision of us exchanging property interests of some kind through a town meeting process would essentially be done and over. That doesn't mean that someone couldn't consider doing this project in another way or under other agreements, but the understanding would be that for the time being, certainly that what has been discussed amongst the parties would be null and void, which is an exchange through a town meeting approval of property interests.
So since I haven't heard you weigh in on this yet, from your perspective, what would happen next in that eventuality?
Well, I'm not trying to be cute here, but I think a number of different things could happen. The short run, as contemplated under the agreement, would be that the transaction wouldn't be going forward, at least in that form, and that the town would probably undertake some restoration of the disturbance that's already been done to the property. There are a number of other possibilities here because there's other ways to accomplish part of this project, all of the project, in some other legal form. That none of that has been discussed or is before a town meeting or before the planning board or even before the select board. But there's a lot of different ways to complete projects. It's just that no one is even, there is no plan B right now for what would happen. If someone came to me and said, can we work on a plan B? I'd probably work with them on it, but that hasn't been part of the discussion.
So back to number 3, the planning board contingency. Can you just explain, and I'm sorry for the redundancy, but if you can just
Sure.
sort of explain this paragraph, number 3.
Yeah, St. Mark's is wants to make sure it's like a standard permitting contingency in a real estate transaction. They want to make sure that before they convey property to the town and accept property from the town, that they have all the approvals that would be required to do the work on the property they would be receiving. Pretty straightforward. They don't want to go forward if the planning board could potentially say no, because it would be a waste of time.
Okay. I don't think I have any other questions. Thanks.
Ms. Houlihan.
Thank you. It's just very difficult for me. Thank you for coming tonight, Jay, for me to really get clarity from your responses. I personally am in the same boat as Ms. Luttrell, that I find this planning board contingency, the last statement, not necessary. And I realize it's in the town meeting one, it's in the planning board contingency and the school board contingency. And it basically says if the town meeting doesn't approve this, then the license term still is invalid and enforceable. So I'm not really sure, it kind of, the MOU doesn't matter because the license is still there. So I'm not really sure why this entire section has to be here.
Hold on. The existing licenses are terminated regardless.
The existing license term is something like 365 days or
The
longer.
existing license is terminated, period, under this agreement. It's only the obligations to complete the transaction that would be deemed null and void. The agreement effectively ends the existing license arrangement regardless.
So if it's terminated, then that sentence still doesn't need to be there because if the license terms contained herein is
because
terminated, why bother
there's a-
having a redundant sentence?
No, there's other license terms that would survive. So the original license to do the work is terminated. But there would be surviving license terms that apply only to the town's restoration of St. Mark's property that had been previously worked on. That would be the only remaining license terms.
So I
The
think this
the
is,
remainder of the license.
I think I'm reflecting our population here in Southborough as well. I think this is very confusing. What license is it referencing then? Because if you're telling us multiple licenses, I'm just very confused because it's not clear to me. And
right,
I
so-
represent, I'm an elected official from this town and I'm not clear. I would hate to be a voice at town meeting encouraging people to do or don't do something if I don't understand it.
Right, so I'll repeat kind of what I said before, because the original licenses are terminating, period. And with the only exception that if this doesn't go forward, the town would retain minimal license rights to do work on St. Mark's property to restore the St. Mark's property to its original condition. That's the only thing that's remaining. Every other bit of the licenses under which work was previously contemplated is terminating, period.
Has there been communication about those terminations? I just have not seen anything in writing. So I've been working under the premise that the license that was circulated was still in existence.
It is still in existence as of today.
But
I don't think the agreement's been signed yet.
got it. Thank you.
Stein.
So, Mr. Tallerman, you just actually clarified it very well, that the purpose of this is so that the town has minimal licensing to restore the site and nothing more than that. Am I
That's
missing
right.
something?
That's right, no, because
Well,
we,
why doesn't
I
it
think-
say that then?
well,
That
it
would
does
be,
say that.
actually,
And-
if it just said that, we wouldn't even be having this conversation, I don't think.
Well, to me, from a legal perspective, obviously, you could always write things differently. But from a legal perspective, to me, the agreement does say that. If it's not as clear as it could be, then I'm always happy to clarify that. I don't think that there's any need to do that, but the effort by the select board in this instance, having heard what the preferences of some people in the community is to do away with the existing more all-consuming licenses and just either sink or swim with a town meeting vote to complete this project. And
You know, I'm gonna have to advocate strongly that you do make this change, because
right,
I feel like, and I am not an attorney, but just as a layperson with reading this, with my simplistic interpretation, it's very open-ended to me. And
yeah, I don't see it that way, but I mean, there's also kind of outside the
terms.
four corners of what the planning board's role is in terms of the licenses, but I don't see it that way, and I apologize if the agreement isn't as clear as it could be to everyone that would be reviewing it. That would be on the lawyers, and we always strive for complete clarity. From the legal perspective in the two parties involved, it's pretty crystal clear that the existing licenses are terminated.
I just have one question, Debbie, that relates to this. So this memorandum of understanding revokes the previous license agreement.
Correct.
So if any of these, so it's revoked within this document. So if any of these approvals don't take place, this document is null and void. Does that mean that that
No, I
revocable
think
license is back in effect?
no,
He said no.
no.
Okay, Mr. Maria.
Hi, Jay.
Hi.
Because this, first I just want to say I'm, as a newly elected member, the most new elected member of the public planning board, I'm kind of offended by the whole paragraph, to be honest. So I spent a little time trying to familiarize myself with Dover, not in the way that you are, of course, but I want to just let you know that, you know, my thinking in that, and just also for the audience and whoever's participating, that, you know, local zoning can regulate and restrict religious and educational uses, provided that the regulations do not result in a prohibition of use. So first, now I'm kind of concerned and confused. Why would we even have some sort of a contingency? Because under Dover, we can't prohibit a use. We can only, as a planning board, we can only, you know, look at any kinds of restrictions. But I want to let you know, in trying to understand this, I read a bunch of different cases, and I just want to let you know. I read the Gardner-Athol area mental health versus zoning board of appeals. I read the Bible Speaks, the outcomes versus the town of Lenox. I read the Sisters of Holy Cross versus Brookline and Newberry Junior College versus City of Brookline. I also read Regis College, and I happened to read your case. And so I think I understand the sensitivity around the protection of what the college sees as part of its mission, that students enjoy the ball fields and playing fields as part of their curriculum. And I just want to say, I don't think there's any doubt about that at all. But when it comes to reasonable regulation, there's some very interesting cases on parking. And so I also read Radcliffe College versus Cambridge, and I read the trustees of Tufts College versus Medford, the two cases in 92 and the case in 93. And the one in 93, I thought was quite interesting, and the court wrote, the whole of Dover Amendment as it presently stands seeks to strike a balance between prevention of local discrimination against educational use and honoring legitimate municipal concerns, and typically finds expression in local zoning boards, local zoning laws. And it goes on to say that, you know, because local zoning laws are intended to be uniformly applied, an educational institution making challenges
basically has, the burden is on them. In that case, the burden was on Tufts to show that they were being discriminated against. So what I find quite interesting here is that there's no local discrimination. There's nothing that prevents, kids having their education and the mission of the school and, the teachers and the faculty or anything like that. But I want to let you know, I found no case at all where parking was allowed without an associated use of, say, a new dormitory, a new, in the case of, I can't remember if it's Tufts, Olin College or Olin Library. So as part of site plan review, I would expect to see something like that. You might have seen the Boston Globe article on the Belmont School, and they're looking to, I think, take basically clear cut 7 acres, and they want to leave 28 trees. And they're doing it for a dormitory. So as part of those calculations, they're looking at the floor area ratio and how much parking do they need, and that sort of thing. And so I think that when we finally receive something from St. Mark's, it should have that. But we kind of know that parking isn't an issue because there has already been a kind of de facto parking lot there.
Before us, what we're looking at is the MOU.
Yeah, so what I'm saying is, I mean, in anticipation that we're going to be receiving something, this planning board has the right to impose any restriction as long as it falls squarely under Dover and we don't, I would hate to see any kind of restriction in an MOU now that basically ties our hands and says, no, you can't use any of the case law that's been, precedent, in interpreting cases of Dover, especially around parking, because it's very clear it has to be the case that's before you. What is before you? Is there a new dorm? Is there a new building? What is the need? And we don't know that right now. Nothing's before us. So I don't think that this paragraph at all is reasonable, because parking is considered reasonable regulation. And I think that this board will do its best to make sure that we fall within the, 4 corners of Dover. So my ask is just to remove the whole paragraph.
Well, so let me step in here. No one is suggesting for a second that if they have to do permitting, that you couldn't utilize the combined strength of all the Tufts College, Boston College, and other cases that examine parking. Of course, it's site plan review, so it's somewhat non-discretionary. I don't think this paragraph is in any way intended to limit or agree that there's a limit to St. Mark's requirement that they apply if it was a required proviso, nor is there anything in this paragraph that limits inherently the discretion of the planning board under the Dover Amendment. All that still exists, which is exactly why St. Mark's assumedly wanted the paragraph in there, because there is a possibility that the planning board could impose restrictions or conditions that would make the project unfeasible for them, and they would want to back out altogether. So it strikes me that the paragraph is actually consistent with the upholding of the planning board's jurisdiction, tempered though it may be under the Dover Amendment, under the zoning bylaws. And I think St. Mark's in that instance is really just signaling that they are going to need a satisfactory decision from the planning board in order to move forward with the underlying transaction. Because if they don't get the parking that they're seeking, then why would they want to go through with the transaction? It's just a straightforward permitting contingency as I see it. And there's no effort here, nor would I opine that there's any effect here on the planning board's jurisdiction by virtue of this agreement.
Well, I appreciate that. I feel somewhat offended. Maybe it's because I don't know how to read, I'm not a lawyer either. But I see this as showing in effect that St. Mark's is signaling that if they don't get what they want, then they're gonna, there's gonna be some alternative procedure. That's never been my understanding, and
I don't see that in the agreement at all.
Or relationship with them.
I don't see that in the agreement. I don't read the agreement that way at all. I think they are going to approach the planning board in good faith to get whatever approvals they need from it, and are probably going to be willing to provide whatever plans they need. Whether they apply the Dover Amendment or not is up to them. That's not before me. I haven't discussed that with them.
Thank you.
So Jay, if you could just explain like the time frame. So do you have a sense of when this document is going to be fully executed?
I don't actually. I meant to check in with Mark today. I think it's I think the two attorneys are satisfied with the current draft. So I think it's really up to the St. Mark's board and for the select board to schedule times to give it the final approval and then execute it. Ostensibly, I know that they would like to do that in advance of town meeting. So there's only a few weeks left in which to accomplish that.
Okay, so the plan is for this document, this PNS to get signed by all the parties noted on it. And then it goes to town meeting.
Yeah.
And then after town meeting, I take it, our process starts with whatever submissions.
I mean, they could, if they wanted to, they could start it beforehand, but my guess is they would wait till after town meeting.
Okay.
I think we gave them,
So-
I think the agreement has a deadline for them to apply.
Okay. And then, so if for some reason, hypothetically, the planning board and St. Mark's could not come to an agreement on the site in whatever form that the site, whatever application they submit, if for some reason we couldn't approve it, or we asked for things that St. Mark's wasn't willing to do, then the whole thing is canceled.
Well, not necessarily. I mean, they could appeal so that they could
They
go
could
to
appeal to
court,
the
I
zoning board of
suppose.
appeals or to whom?
I'd have to go back and look and see if you have a baked in 4817 process
We are.
under your site plan review.
Okay, you're right. I'm sorry. It does say in here, subject of an appeal. Okay.
Yeah.
So. And then, so hypothetically, this could get executed, then come to us after town meeting. Not go forward. The appeal could get lost, and then. The deal would be canceled, and then there would be the licensing, and I just want to hammer this point down for my purposes anyway, the last time. The licensing is limited to, in that event. Just the basic mitigation of the site. To
Yeah.
reinstate it to its. What,
Correct.
natural state, previous state?
Yep. Correct.
We want to move on to road discontinuance since we have.
Yeah, because I apologize. I have I've got about 8 minutes left.
Okay, so on to the road discontinuance. So from what I can tell, the St. Mark Street, the layout now has never been accepted as a town road. So why would we need to discontinue it? And on the previous layout has never been discontinued.
My understanding was that it was. If that's not the case, then so be it. My understanding is that it is a public way.
Well, it
That
was
could
never
be-
accepted by town meeting.
It's not the only way for it to become a public way, but I mean, you might have more information than I have, but my understanding is that it is a public way.
So if it's not
If
accepted
it's not
at
a
town
public
meeting.
way, then we don't have to discontinue it. But my understanding is that maybe because it's an older way that predates the current method, that it might be considered a public way, or my understanding is that it is considered a public way.
Well, I
If
don't
it, if
think
it's
it had a
not,
different-
then the town meeting would skip that part of it altogether.
And the other question is, there are different levels of town meeting approval, either 2/3 or a simple majority based on how the
Is this-
town acquired the property. Do we know whether we own it by fee or easement?
For which, the discontinuance vote or the conveyance vote?
The discontinuance road.
No, discontinuance is a simple majority. But the
Even if
conveyances,
it's an
the
easement?
conveyances are 2/3 votes, and the acceptance is a 2/3.
So if town meeting St. Mark's in the warrant article, I mean, town meeting votes to discontinue the road, will that portion of the road be closed off until the new road is built? Or what's
You
the
know,
plan there?
I think from a liability perspective, that's likely. I'm not involved in the development of an operation and maintenance plan for the project. But from, as a lawyer and looking at the liability questions, I would probably recommend that it not be made open for public travel after the discontinuance. The discontinuance, there's no obligation. Now, a town can, I suppose, let it remain open if they want, but there's always liability concerns in that instance.
In previous roads that were discontinued, we had a legal description of it within the warrant. Is that the intention this time?
I believe that there's going to be a reference to a plan that will be on file. Yes, I've worked on an initial draft of a warrant article. It's not final yet, but there's going to be a reference to the plan, more or less the plan that I think you have seen. I know it's still going through some revisions as of this afternoon.
So
But
that's
there's
a
gonna be-
surveyed plan?
I'm sorry, say again?
That's a surveyed plan? Okay,
It's going to be a plan that accurately describes the portion that's being discontinued. It would be on file with the town clerk in advance of town meeting.
okay. Mr. Stein? Ms. Houlihan?
I guess the implication, if the town does not discontinue the road,
Then it remains a public way. And the town would have to maintain it in that instance unless the select board takes a vote, which doesn't require a town meeting to abandon the maintenance of it during the construction period, which they can do under a different section of the law, but it would remain a public way.
Mr. Maria?
Hi, just one question. There's a public way there and a revocable license agreement for Stonewall that we leased to St. Mark's. Is that impacted in any way by discontinuing the road?
I'm not familiar with that. The only portion that's being discontinued or contemplated for discontinuance is the portion shown on the plan. So I don't think it otherwise affects any other element of a public way or any other way maintained by the town or St. Mark's, to my knowledge.
Thank you.
Oh, so Jay, usually when you discontinue a road, the abutters own from the midline to their property on either side, but.
Not
this is
always.
not the case?
We're still retaining the ownership. We're not abandoning the ownership. we're just discontinuing it as a public way. We're not conveying, it's still town-owned property until it was either conveyed to St. Mark's or, and if it's not, it remains town-owned property, just not a public way. Discontinuance just takes away the public element of it, doesn't have anything to do with the ownership elements of it.
But the intention is to convey it to St. Mark's, isn't it?
Well, that's the intention, yeah.
Mr. Stein?
So Jay, thank you. This has actually been very helpful and thank you for coming tonight, for me anyway. One thing that I would like to just hear your opinion on is, from a global, view, high view of this. Going forward, so that we don't end up, or we can try not to end up in this kind of situation again, where, we had a DPW superintendent that didn't really, follow the normal or the prescribed course of approval of projects. And I feel like this could have been done better. Would you agree with that? And, what training can be done in the future for somebody in the position of a DPW superintendent to prevent this from happening?
So I'm not going to comment on what someone else did or didn't do and whether it was right or wrong. I think that good communication is always important for local boards, and to the extent that there wasn't an ideal amount of communication, then that's something people can always shore up. I have not, and I've said this publicly, I have not discerned in terms of the things that I've been involved in, conveyances and completing of a project, discerned any legal error. To the extent that people are dissatisfied with how it went, whether they be members of the public or boards, then that obviously means that things could be done in a way that brings everyone in on the plans in a way to make everyone more happy. From a legal perspective, again, I'm not discerning any legal error, nor would I comment on that in this forum. I just think it's unfortunate that this particular issue has received the amount of controversy that it has. It seems like a nice little project, but the fact that people are dissatisfied means that there's something that people could do better from a communication perspective. And I think the select board takes that really seriously. And if there was another project like this, I'm sure there would be a lot more of a collaborative process to avoid, this kind of disputes in the future.
And one last question. The discontinuance as it relates to the purchase and sale agreement. And I'm sorry, I'm not familiar with the PNS enough to know this. Is there anything in the PNS that references this discontinuance?
Yeah.
Okay.
Yeah.
Thank you.
Yeah. It was actually changed. We were going to do discontinuance in the future. At the time we accepted it, it just seemed to make more sense to discontinue it now because there's going to be work getting done. So we would front load discontinuance now, and then when the new roadway was done, potentially then we would do the acceptance later. But yeah, it got this in this version, discontinuance is in there on the front end.
So sorry, the discontinuance is going to happen first?
No, it's all part of the same article.
Okay, thanks.
Karina has a question.
This is gonna be hard because I'm really close to the other microphone.
Right.
So I have two questions.
And
Concom-
Karina, I apologize, but I really have like zero time, so I'm happy to answer a question.
right, one
if it's a quick
question.
one.
One fast question. Is there any unusual or impactful risk that any of this information, like the discontinuance plan, or the MOU, that on the town that you foresee, or do you?
No, I've never seen any risk of anything in any part of this project from the inception. I see zero risk in moving forward. I think that we've gone beyond belt and suspenders in terms of clearing this up. For whatever reason that this became a controversy, and I'm not diminishing the reasons that it became a controversy, I don't see from a legal perspective as the town's attorney any risk whatsoever.
Other than maybe the cost of mitigating if the process falls through. Mitigating the St. Mark's property back. the cost of it.
That's up to the voters. If the voters want to forego receipt of all of the monies that are available through grants and otherwise and want to abandon the project, then yeah, the town would be responsible for whatever remaining costs are out there on their own. And that would be, again, something for the Legislative Assembly, which is town meeting.
Okay, thanks.
And I apologize, I would be happy to spend more time with you. And I'm happy to schedule another session. I really have to be somewhere at 8 o'clock.
Okay, thank you, Jay.
All
Appreciate
right,
it.
thank you. Talk soon.
So do we want to communicate something to the select board? I mean, I think at the very least, the alternatively provide notice that such approval is not required should come out of the contingency. I can understand why the contingency is there because that happens in real estate deals all the time. Like when a proponent comes before us, they usually don't own the land, but they have an agreement that they have to get their approvals, and if they don't get their approvals, then, so I think, to me, the rest of this seems pretty much that, except for that provide notice that such approval is not required, I find disturbing. It's the, 1, 2, 3, third from the last sentence under the planning board contingency. Under to facilitate the provisions of this paragraph, the school shall apply for any required planning board or other municipal approval, or alternatively provide notice that such approval is not required.
Memorandum purchase. I'm sorry, I'm looking at memorandum of purchase of real estate.
February 2023.
There's no date on this. It says this date, January 2023.
Oh, that's an old draft.
That's what's.
There's two in the Dropbox. So there's the January 17th and the February 7th. Both taken from the, if you go to item 12 under.
Oh, so the February 7th like deletes most of the licensing stuff, which is probably why there were all those questions on the license.
Did you find it?
So is planning board contingency number 3 still? Yeah, okay.
So that sentence was, well, that whole to facilitate provisions was added to this MOU. And the alternatively provide notice that such approval is not required. Okay.
So is it, I wish the Tellerman was still on there. Is this saying that the school is going to provide notice that such approval? Who's providing notice that such approval?
Yeah, it would be the school, but it's my understanding that this is Jay's language that he put in. So there was the first MOU that you were looking at from January, that the select board asked him to remove the license agreement, and he added this.
Okay, well, Mr. Tellerman said he would be willing to come to a subsequent meeting. Why don't we ask him to come to March 13th?
Because I think the select board is going to sign this tomorrow.
Well, then I guess, go ahead.
Can I mention one other?
Sure.
There's another sentence, after quotes, the planning board approval, is the planning board approval should not be deemed to have been obtained if the planning board approval is a subject of an appeal. I assume that means in a court, right? Or contains conditions unacceptable to the school. So I would like to, I understand the appeal, but I would like to remove or contains conditions unacceptable to the school.
Well, I think I'm going to play devil's advocate for a second. I think what he would say is if we impose something that the school finds untenable and undoable, they want to be able to back out.
Also note that they could appeal. So if you go through site plan process and the planning board insists on a condition that the applicant is not in favor of and no way wants to do it, but the planning board says, well, too bad, this is the condition we want, and the decision is written and submitted and filed, that the applicant can appeal that. So it falls back to the appeal. Anyway, I think that's how that would work. So it's just kind of a second tier. Or contains conditions unacceptable to the school, if they don't like the conditions, they'll appeal it. And it goes back to that appeal.
That's not explicitly stated though. That's like legal jargon.
Yeah,
That's where the legal, like, let's be interesting with our writing.
Mm.
I feel like that's where it's giving that, we don't have to appeal. We can just say this is an unacceptable condition and we now are pulling out. But that's not how we've ever worked with the planning with St. Mark. So I think it's kind of an unreasonable addition to something when that's not at all our track record with working with St. Mark's.
Well, the interesting thing though is it could be how a private sector proponent would be working with the seller of a property. So for example, somebody could be buying a parcel contingent on permits being done. And if those permits don't get done, then the deal's off. I think that's how this is structured.
Yeah, that's how I see this.
But that's what I was saying, under the Dover Amendment, and even though they might not invoke Dover, we still consider parking reasonable regulation. We can't outright
Absolutely.
deny it. It's just a matter of conditions. So that whole structured sentence doesn't make any sense. Because they will get a permit. Just a matter of what it might look like. So they can't back out. Because under Dover, we can't deny it.
So see, this is the thing about the Dover Amendment. I've always to me, the Dover Amendment is something that's in place to protect the school from not being able to do something it needs in order to like exist.
Right.
It's like something to maintain its like existence as a school.
Right.
Well, I mean, it doesn't mean that they can just do anything they want at any time and completely ignore the town code.
I totally agree with you, but
Except for the court has a very broad definition of what the school requires to function.
and there's no building or development that's associated with this parking. This is unprecedented. I looked at every case that I could find, so they could say, oh, we want to take our ball and go home. I guess if that's what they want to write into that agreement, we don't get what we want to get out of the agreement. I'd be happy with that if that's what they want to put. I would prefer something like that than to say, oh my gosh, whatever the sentence. Subjects, yeah, that. Because the way the sentence is structured says the planning board approval shall not be deemed to have been obtained. If the planning board approval is the subject of an appeal, which is not really true either. If the appeal is successful, I guess, okay, or contains conditions unacceptable to the school. I think that they want to say that the deal is off if it's not acceptable to the school. Because it's very possible, because this is really unprecedented, there's no building or anything associated with this ball field, parking for the ball field, that it's very possible that they may not like a condition that the planning board imposes on them.
Then the whole thing's off. That'll be that, or it'll get appealed. What's your concern specifically? Like, what is the outcome that you are envisioning that you would feel is not right, or you don't?
Well, I don't think it's factual. I mean, planning board approval, we could still give approval, but they may not like it. So I think it's factually not correct. It's not true that the planning board shall not give approval if the conditions aren't satisfactory to the school. Those two things just don't go. It's just a wrong statement. It just doesn't make any sense.
Well, so it defines the planning board approval.
Yeah, but that's not our definition of, we can give an approval, it might have conditions. That may not be satisfactory to St. Mark's, but it's still an approval. We don't want this agreement to define what's a planning board approval. We don't know what that looks like yet because we don't have a site plan in front of us. Right? But we can guess that it's either wholly what they asked for, or it has a few conditions. So I'm kind of, I said, I'm a little offended that they are trying to dictate what our approvals look like.
Even if the planning board
don't know yet.
approves a project, the applicant doesn't have to act on it. Right? So think about that. So the planning board can go ahead and
Right.
approve, and a decision is written and filed,
Yes,
but the applicant, bottom line, can walk away.
yes, and it's still an approval, which isn't what that statement says, and they can appeal it, which isn't really what that statement says. So I would request that we remove that statement as well. Is that problematic?
The whole thing or just the or, the condition?
Well, to be honest, if it's subject to an appeal, it's only if the appeal wins, if it prevails in court. So I would say the whole sentence.
Yeah, I guess.
I mean, obviously.
Well, I
if the
think that
court remands it
if
back
it's
to us,
appealed, they don't, I mean, that could be years. So if it's appealed, they want to pull out.
Yes, but we would still have an approval on the books. If we give them an approval, but they don't like it, it's not true that it's not an approval because they take it to court. It's just not correct.
Well, they're not the only ones that can take it to court.
Right. Right. No, I just
So
object
they're-
that statement doesn't make any sense. I think from what town council was saying is the reason that's there is they would like to say that if they don't approve of the planning board approval with whatever conditions, that this is all null and void. That's a different statement. That's maybe a statement. That's a true statement. But it's not in this paragraph.
The wording is funky if you read it.
It's funky. I don't think it's true. It's still an approval. We can go through this whole process and give an approval. They don't have to act on it. They may not like it. They might not like the deal, but it's still on the books as an approval. Even if it gets appealed, it's still an approval unless it gets remanded back to us, to be honest.
Yeah,
And
but
what-
they don't want to wait years and years and years.
Right. So, but I don't agree with that. I mean, it would still be an approval.
So I don't have a problem with any of this except for that. Provide notice that such approval is not required. I think that approval is required and that's opening the door to something that's not true. What's your thought on this, Jesse?
I'm in agreement with you.
Ms. Houlihan?
I agree with Deb. I think that one statement should just be removed. Because it defines what a planning board approval is, and I would agree with her. It's actually not just inaccurate. I don't know why it's even there. The sentence can still go on without it. And then I would agree with your recommendation, to remove the.
Oh, you need your mic.
I was just saying that I would agree with Deb's point that after the parentheses, I think it's the first sentence, the planning board approval should not be deemed to have been obtained if the planning board approval is the subject of an appeal or contains conditions unacceptable to the school. I would say to strike. And then I would also agree with your recommendation, Mimi.
So that whole sentence or conditions unacceptable?
I think the whole sentence could be removed and it wouldn't affect the paragraph at all.
So if it's subject to an appeal, the deal is still valid. And they would have to wait years for the outcome of that appeal.
Yeah, I guess that's a good point because it doesn't add that in anywhere else. Where if it is appealed, you're right, that's multiple years potentially because it goes right to the court, not to the zoning board. So I would remove the or contains conditions unacceptable to the school.
Okay.
But I guess it's like, I guess they're not gonna rewrite it. I guess the whole point is that the planning board approval shall not be deemed to have been obtained. I think the point is it's been obtained. But if it is appealed, then you can come out of the thing. Do you know what I'm saying? It's the play on words just doesn't make it read right.
So removal of those two sentences. We're good with that. Anything on the road? I would say we should determine whether that road has ever been accepted for us to.
This is not a submission at this time. Right, so.
Well, we need to,
expect comment on this now?
no, not now.
Okay.
So on the MOU, yes. So
Oh, I hear.
I'll put something together on that for tomorrow.
So maybe
Okay.
on the MOU, it's that second sentence and the last sentence that the planning board is recommending to strike? Or is it the fragment of the second sentence?
So, provide notice that such approval is not required.
Just the fragment.
And then,
Just point to it on the screen.
And or that, and or conditions unacceptable to the school.
That, the second half of the second.
Yes,
sentence.
yeah.
And then just this, provide notice that such approval
It's not required.
is not required.
Yeah. Okay. All right. We ready to move on?
Yes.
Next item, public hearing 241, 245 Turnpike Road. Mr. Stein.
I make a motion that we continue the public hearing for 241, 245 Turnpike Road, car condos major site plan approval to March 13th at 7:05 PM.
Is there a second?
Oh, that's my job now. Second.
Are you
So,
going to continue the lid as well, or are you going to do a separate motion?
Or was gonna do a separate motion.
Okay. Just making sure.
so we have a motion and a second. Any discussion? All in favor, Latrell, yes.
Stein, yes.
Houlihan, yes.
Demiria, yes.
Mr. Stein.
I'd like to make a motion, we extend the public hearing for 241, 245 Turnpike Road, car condos special permit for lower impact development to March 13th, 7:05 PM.
Second.
A motion and a second. Any discussion? All in favor, Latrell, yes.
Stein, yes.
Houlihan, yes.
Demiria, yes.
Okay, the next item, a public hearing, 325 Turnpike Road. They've also requested a continuance. Mr. Stein.
Making the motion that we extend the decision deadline to March 17th, 2023 for 325 Turnpike Road, sound barrier wall modification to a previously approved site plan.
Is there a second?
Second.
The motion and a second. Any discussion? All in favor, Latrell, yes.
Stein, yes.
Houlihan, yes.
Abstain.
Mr. Stein.
And I'd like to make a motion that we extend the public hearing for 325 Turnpike Road, sound barrier wall modification to a previously approved major site plan approval to March 13th at 7:10 PM.
Second.
I have a motion and a second. Any discussion? All in favor, Latrell, yes.
Stein, yes.
Houlihan, yes.
I abstain.
Thank you. Next item on the agenda is Master Plan Implementation Committee briefing. Debbie, do you have anything on that?
I'll just give a very brief update. The committee's been, has met, several times now to, first, organize themselves into, what we're calling affinity groups. I think I might have just described to the board, that, the goals, by chapter were sort of grouped, for example, in what we call them affinity groups. So one, for example, local government, another is finance and technology, another one's environment and open space, and like that. So each of the master plan implementation committee members were called liaisons to the different boards, have reviewed the goals, I would say, cross-filed them with some of the select board goals, which are some of them are select board goals. They're very similar. And we are now getting started with going out and meeting with each of our boards. We confirmed that the first official update from the committee would be, I think, our April 3rd meeting to the planning board. So right now we're working on what would be the correct kind of deliverable to give to the planning board. So we have one of the members created a kind of like a form to collect information from the boards and committees. And then each member will put, what we're thinking is each member will put the information, sort of the update on an Excel spreadsheet, and then that will sort of suffice to, give to the planning board on a quarterly basis. And the master plan implementation committee members are planning to meet before the quarterly report to the planning boards, to sort of to check in, review the report before it's given as a deliverable. So I'd say we're right on track. Some of the members have already met with their team, and boards and committees or departments. And the first meeting is just really kind of setting the baseline so they understand that we'll be checking in with them, with what frequency, and just really understanding, what it is that we're doing. We're not tracking their goals. We're asking that the boards and committees track their own goals, but what we're doing is collecting their progress. So I think we're right on track. It's, just starting to take off, and April 3rd will be our official kind of report back to the planning board.
Great, thank you very much.
Yep.
Does anyone have any comment on that?
Good job.
Appreciate it. You're stretched thin these days, so thank you very much.
Okay, the next item on the agenda is a public hearing, the tree protection bylaw warrant article. Is that me?
Yes, it is.
I was going to go through my PowerPoint, but since we're running late tonight, I'll save it for the next one. But I did add one slide and wanted your opinion on it. I had cross-referenced the sections of the bylaw with the sections of Mass General Law to show that it's closely parallels. And just for anybody unfamiliar, the tree protection bylaw was at special town meeting and failed. And we are bringing it back. We have added the amendments that were requested by the select board into it. We've also removed any reference to the drip line that seemed to be unfavorable to the legislative body. So that's the slide that I added, and wonder if that's helpful or not.
Make that size smaller so you can see or just
So those are each of the sections of the bylaw. The purpose obviously is not for Mass General Law. It's unique to Southborough, and what we're trying to achieve with this bylaw. Definitions, there are very few definitions, so we've added a lot. But what we have also used the ones that are in the bylaw. And then the rest follows pretty closely to either Mass General Law or, Chapter 87 or the Scenic Road Law, Chapter 40, Section 15C. Also, the tree replacement is from our Southborough Code 153-4, which requires us to have a tree planting program.
My one comment would be to just increase the text size of the MGL references. Because when you first look at it, it's a little tougher to read.
Yeah, it'll be pretty hard to read on a big screen at town meeting.
I will try.
I can help you with that. My one
Thank you,
question
ma'am.
would be, like when I look at a slide, I want to be like, what's the aha? Like, what is this trying to tell me? So what this tells me when I look at this is that everything is already contained in all of these other chapters in either Mass General Law or our own Southborough Code. Is that true? So except for purpose, you have the unique to Southborough. Everything else is covered in a code. It's not new language.
That's correct.
I think that I'll help you. I think like a takeaway, like an aha statement at the top would be helpful. I like that slide.
Thank you. PowerPoint is not my forte.
I like it too.
Yeah, well, any questions? Is there anyone here? Anyone in Zoom land? No, okay.
We currently have 8 attendees and no hands raised in the Zoom room. Attendee room.
So, Mr. Stein,
Make the motion that we extend the public hearing for the tree protection bylaw warrant article to March 13th at 7:15 PM.
Second,
we have a motion and a second. Any discussion? All in favor, Latrell, yes?
Stein, yes?
Houlihan, yes.
Demiria, yes.
The next item on the agenda is a public hearing for the Scenic Road warrant article. Ms. Houlihan, is this you?
Yes, thanks, Ms. Luttrell. So this is just the scenic road warrant article. This is where we are requesting that the town at town meeting vote to accept 67 additional streets. And this is really for simplification of town administrative and logistical scenic road management. And that will be presented at town meeting and then up for vote. It was partially presented last town meeting. It was taken off the queue for the special town meeting. So this will be kind of a new fresh start for this one. I don't know if anyone has any questions.
Any questions? Any questions in Zoom land? Okay. Mr. Stein?
Make the motion that we extend the public hearing for the scenic road warrant article to March 13th at 7:20 PM.
Second,
We have a motion and a second. Any discussion? All in favor, Latrell, yes?
Stein, yes?
Houlihan, yes.
Demiria, yes.
Very good. The next item on the agenda is a public hearing Conservation zoning amendment 174-8.9 wetland and floodplain district. And also conservation zoning amendment 174-13.5 stormwater and erosion control.
Good evening. Thank you. Melissa Danza.
We have Melissa Danza, conservation agent, on the panel.
Can everyone hear me okay?
Hi, Melissa.
Hi.
Welcome.
Thank you. So I will get started with just the wetland and floodplain district first. And that is,
Sorry,
you guys hear me okay?
I'm not hearing her.
Hello?
Can you hear us, Melissa?
I can hear you. Can you hear me?
No, Melissa, we're not hearing you. Second here.
Interesting. Okay.
Try again.
Understand.
No, there we go. Turn your volume. Now try.
Can you hear anything?
Yeah.
There you go.
Yeah. Okay.
Volume.
All right. Well, thank you guys for having me today. So first off, we have the wetland and floodplain district. As a overview for this bylaw is just bringing Southborough up to the National Flood Insurance Program's standard through FEMA. Because Southborough has floodplain within their community, every city and town in Massachusetts that is an inland community will basically have this exact bylaw. Coastal communities have a little bit more additional, for the specifics of coastal flooding, but the basics of this bylaw is just to remain within the FEMA floodplain standards, mostly because our state standards aren't as strict as the federal standards. So that's why each community has to have their separate bylaw to bring those up to code. So none of the changes, even though it looks a lot, there's a lot of red lines on this document. This doesn't change any process. It doesn't change any flood zone areas. It is just adding some necessary definitions and stating who the appropriate person is to contact if you have questions about floodplain maps, and also ensuring that we keep records of any structures that are built within the floodplain. So that's kind of the substance of the wetland and floodplain district bylaw.
Now, is this coming out of the zoning code also, Melissa?
Nope. So this is an existing bylaw that we are amending in place.
Okay, so it's going to stay in the zoning code?
Yeah, because it's going to be an overlay district.
Oh, okay. Any questions?
No.
All right. So for the stormwater bylaw, this bylaw, we are having two motions. One is to be for the complete removal of the bylaw from the zoning code in its entirety. And that vote will be contingent upon the successful reinsertion of the amended bylaw within the general bylaws, which is also contingent on the first one passing as well. So they are kind of contingent on each other. If anything does fail, ultimately the bylaw will remain exactly the same. We would address it at another meeting. We would just kind of leave it as it is if one of the other fails. The main changes are to the thresholds for the applicability section to be more equitable throughout all of the zoning districts. A lot of the old residential C lots are about a half acre. So if they were to disturb 50%, which would be only a quarter acre, they'd need a stormwater management permit. So we are trying to be more consistent. So we looked at the lot sizes and what the average size would be on projects that we would have liked to see required versus ones that kind of we received that weren't as kind of applicable as we would have thought based on what the construction was. Sometimes it was even an addition would trigger it. So we made it more equitable to be kind of a flat standard 1 acre, which is also the EPA standard for the general construction permit. And we also included the addition of A&R lots, which, was one aspect that I think most of the boards were getting concerned about in terms of construction sediment control. So this will allow us to now more heavily enforce the kind of non-segmentation of projects. So we added some definitions about what a common plan of land is and common sale, so that those A&R projects are now captured by the stormwater management permit. We're also, for projects that disturb under an acre, have kind of an administrative review process, so that kind of the smaller residential additions, we do have some enforcement, mostly just for the sediment and stormwater runoff. That is one major thing that we've been noticing. So this would also help us implement construction entrances for new properties so that dirt's not being tracked out into the road. On hilly sites, making sure abutters are being protected more properly. And this would all be done through the building permit process, since it all is online on Viewpoint. And then, the major points are, those, and then the appeal and bringing it out of the zoning in general. So the appeal would now be going to Superior Court versus the Zoning Board of Appeals. That was something that the commission felt pretty strong about, even if we didn't move it out of the zoning code, to have it go to a more appropriate code for a court for stormwater. And since the last meeting, I did meet with Mr. Barlini after he had some questions and we went over the bylaws. He still did have the concern about the appeals going to Superior Court. And I do owe him some more language about those exceptions and applicability sections, because they are a little bit confusing because they kind of reference each other. So I'm still working on that this week to see if there's either a better way for me to clarify or my commission during town meeting, or if there's a better way that we can revise that language to make it more consistent and readable. I think that's the basis of the changes. So welcome to answer any questions.
Thank you, Melissa. Any questions, Mr. Mills?
No question. Thank you, Melissa.
Mr. Stein? Ms. Houlihan?
No, thank you, Melissa.
Mr. Maria?
Hi, Melissa. It's Debbie Jamuria. Thanks for that. At the last meeting, I had only one concern about the stormwater and erosion control actually coming out of the zoning code and going into the general laws. And the only reason was because it's a higher threshold at town meeting to change zoning. And, but I am very sympathetic to what you're saying that, especially given the history of what's happened previously. I was just wondering if in other towns they have similar stormwater and erosion control bylaws, and are they in zoning or are they in the general laws? Would you know?
Yep. So every town and city that's not a small community does require this bylaw because of the EPA standards. So most of them are in the general bylaws. There are some in zoning. It kind of just was the wish of the town of where it wants to be put. But there are quite many of them within just the general bylaws themselves. And those are typically the ones are primarily promulgated by the Conservation Commission. The ones that remain in zoning are usually a separate committee made up of boards, of the various permitting boards. And that's kind of, it's a better fit, when it has kind of a member from planning, a member from zoning, et cetera. With the Conservation Commission, since we are the only ones enforcing and promulgating the rules, it seemed to make more sense and align with other towns that have the similar path to be in the general bylaws.
Thank you for that. Actually, that makes a lot of sense. I really appreciate you going into the detail and I support it. Thank you very much.
Thank you. Oh, and I know one question was what the specifics of the past waiver was of the bylaw. So I did look into it, and it was the School Street Solar project. And I think a lot of it was a little bit of miscommunication. It was between two building inspectors. One was leaving and Mark Robideau was coming in at the time. It was also under the when the big solar incentives were popular. So there was kind of some difference in opinion of the applicability, kind of what you guys were talking about earlier with the Dover Amendment. There was kind of some similar language for solar at the time, but it should not have, overcome the local bylaws, especially the SMP bylaw. But it was weighed by the building commissioner and upheld that way. And because of we weren't kind of notified, it's not, from the dates I could put together, it appeared as if the commission didn't know about it until after 30 days. So it could not be appealed.
Thanks, Melissa. Any questions from anyone here? Anyone in Zoom land?
We currently have 5 attendees in the Zoom, 9 attendees in the Zoom room, no hands raised.
So we continue?
Yes, both of these should be continued to the March 13th planning board meeting to 7:25 p.m. Continue both of them.
So I'll do 2 separate motions, if that's okay. I offered to let him do it. I'd like to make a motion to continue the public hearing for conservation zoning amendment 174 8.9 wetland and floodplain district to March 13th at 7:25 p.m.
Second.
Very good. I have a motion and a second. Any discussion? All in favor, Latrell, yes.
Mills, yes.
Stein, yes.
Houlihan, yes.
Demiria, yes.
Mr. Stein.
And the motion is to extend the public hearing for conservation zoning amendment 174-13.5 stormwater and erosion control to March 13th at 7:25 p.m.
Second.
Very good. I have a motion and a second. Any discussion? Seeing none, all in favor, Latrell, yes.
Mills, yes.
Stein, yes.
Houlihan, yes.
Demiria, yes.
Thank you, Melissa.
Thank you, board members. I appreciate it.
The next item on the agenda, finally, A&R 150 Parkerville Road. Karina, you want to bring us up to date?
Sure. Can you put that on the screen?
Yep.
Colleen's gonna pull that on the screen. So, planning received A&R application, approval not required for 150 Parkerville Road regarding assessors map 19, parcel 20D, map 9, parcel 88, map 19, parcel 87. On February 21st, the application was filed with the town clerk. The applicant is Adam Fana. I keep wanting to call you Andrew, I'm sorry. We have so many Andrews. Adam Fana, and his, is it your wife?
Yes, yeah.
So what we have is an A&R. If you look at the screen, in the middle is lot 1, where there's an existing house. That is 150 Parkerville. Below that, you'll see parcel A, which looks like it's made up of 2 triangles, but in essence, a smaller triangle on the north side, or on the north side. The intent is to separate that triangle from parcel A and convey it to, and it will become part of lot 1. Okay, and parcel A will remain a non-buildable lot.
Sorry, this triangle here?
Yes, that small triangle. The intent is that will join lot 1. And on the north side, I'm sorry, that was the south side. So on the north side, you'll see parcel C, almost a square shape. And that parcel is taken from 177 Middle Road. Is that 177? Yeah, Middle Road. And you can see the driveways across the back there to lot 1. And the property line, I believe, was cut right there, keeping a shed and the septic for 177 on the property for number 177, lot 2. So that parcel C, the intent is to convey that also to lot 1 on that side. So when we received this plan, we reviewed it. Some changes were made. The deed references were checked. We made sure everything was in order. They added any easements and driveways to show the property, the wetlands, to show the features there as required by our local bylaw. And that's pretty much it. So if Adam has any additional information you want to provide.
Yeah, any questions regarding the problem? Right. Fan 150 Martinsville Road, Shelter. Is there any? Like, Adam Faniff, 150 Parkville Road, Southborough. So what you're looking at behind you is basically a culmination of family development that goes back to the early 70s. All the parcels included are owned by family members present here in the room. That parcel C that you're looking at, if you go up to the north corner right there, that's basically just general housekeeping. So that is the access to my home. I maintain that year round, take care of it year round. The topography of that land isn't conducive for anything that lot number 2 could ever build on. The gradient is particularly steep and we traverse it in that particular location because of the angle of topography. So my sister and brother-in-law were willing to convey that to me so that I can clean up the language pertaining to the easements in the event that there's ever a sale of that property. My kids or her kids or whomever it may be wouldn't have to go through the nightmare of a piece of property that lot 2 can't use in any feasible manner, but my property is responsible for all of the maintenance on, with the exception of the utility easement, which is all underground. So ideally, it never needs to be worked on. Parcel A is in a trust. My aunt, uncle, present in the room, own. That is a landlocked piece of land that conveying it to my land prevents my kids from driving wiffle balls into my house. One, we're already kind of using it as a family chunk of land. It's a flat piece of land. And it really isn't, it's more, once again, cleaning up a piece of property that my house already utilizes, my kids already utilize. And if something changed with that trust, we would get into a situation with the he said, she said, that's mine, that's yours situation. It's really just general housekeeping so that if the land ever changes hands, your job's easier the next time someone's in front of you. That's really what this is about.
Thank you very much. Any questions, Mr. Mills?
Yeah, they're gonna give you the shed too that's on that land.
Well, that was, yeah.
No question.
Mr. Stein?
No questions.
Ms. Houlihan?
No questions.
Mr. Maria?
No questions.
And I also have no questions. Are you gonna make this motion or is it still Mr. Stein?
Here's the endorsement form if you need to read the location.
Madam Chair, I make a motion, we endorse the A&R for 150 Parkerville Road, map 19-20D, map 9-88, map 19-87, per the request of the applicant.
Second.
I have a motion and a second. Any discussion? All in favor, Latrell, yes.
Mills, yes.
Stein, yes.
Houlihan, yes.
Demiria, yes.
Thank you very much. And thank you, Karina. It's all your diligence and hard work that make things so much easier when they come before us. Then there are no questions.
Very welcome. They helped a lot too. They provided everything I asked for.
Thanks for being our
Thank
tier
you.
section today.
Yeah, thanks for coming in.
I even brought them in case there were any questions. You wouldn't have Fully prepared.
We loved having an audience.
We got all the neighbors.
It was riveting, by the way.
Always is. Thank you. The next item on the agenda, MBTA communities. I have one update that the chair of the select board had reached out to me and asked if we could
have a joint meeting with them, Shopsy, in advisory to discuss MBTA communities and how it affects Southborough and kind of look more at a cost benefit analysis, which I think you brought up at the very beginning of all of this, Marnie. And they put out, she said either 3/7 or 3/21. I said I would bring that to the board.
I'm away March 7th. No, I feel kind of obligated to be part of the MBTA conversation, so if
Yeah,
people
so
can do
do
the 21st, oh, because you're shop say. It's a tough one.
Yeah. Is there any way we can do it?
Oh, I can dial in, like as long as it's Zoom,
Oh, yeah.
I'll be in a warmer climate, but I'll be dialing in. Yeah, the 7th I can do. If we dial in, I can dial in.
Can everyone else do the 7th?
So this is a joint meeting with the select board
Yes.
for MBTA communities.
Shopsy and advisory.
And Shopsy and advisor would be there too, but planning board will be.
Yeah.
For that discussion. And you'll let me know if there's anything else you want on that agenda in case something else. Is that me specifically for that or is that an agenda item on that?
I think it will be an agenda item on
On
theirs.
their regular.
And I'll let her know. I don't know what works for the other committees, but I'll tell her 3/7 would work for
Okay,
us.
thanks.
And I know there've been a lot of articles recently on what other towns and cities are doing on this, and we're past the easy part, having the action plan, which was really not a very heavy lift now. Towns are actually looking at what this is going to mean for them, whether it's doable or not. So this is a good time to have this conversation townwide, because this is a huge thing, and I think all hands need to be on deck for this. Do you have anything you want to add, Colleen?
No. No, just that we got, Mimi did sign off on the award letter for the original grant for the technical assistance today. So we did get that. I was just looking for a copy.
And there's still the CHAPA services that the town was awarded.
Engagement
For
services,
public
right?
engagement services, which is good. And also the I was informed that, I think by Mark Purple and the treasurer, that the ARPA funds will be available for all three of those topics that we had in the budget for fiscal year 24, which includes a portion for MBTA communities support services.
Oh, good.
Can I ask you a quick question? When were we notified that there was going to be this joint meeting on March 7th?
Kathy Cook called me Friday.
Friday? Okay. Thank you.
Do you want to push it out further? Do you want to see if we can?
No, you know, my concern is Shopsy just met this morning and I don't recall this being mentioned. So I'm just hopeful that Shopsy will have a quorum for this meeting. I'm putting on my Shopsy hat now and asking
Yeah.
the question. Thank you.
So anything else on this subject? Move on to St. Mark's Street location, planning board review under Mass General Law, Chapter 41, 81I, Section 81I.
So I can give you a quick update on where we are. So since the last meeting on February 6th, we had Fuss and O'Neill provide a cost estimate for the review fee for reviewing the plans submitted by prepared by VHB and submitted by the select board to the planning board. That was signed by Mark Purple, so we'll be providing invoices to him through the planning board, through the planning office. We also received on Thursday the review comments from Fuss and O'Neill, which were distributed today. And I believe we provided them to VHB and also Mark Purple and Kathy Cook. In the interim, let me see here. We had some questions come in. Deb DeMoria, Debbie, you provided an email with some questions that you had, I believe, related to this. And I think, just see what else.
Just want to say thank you, Karina. So yeah, my question was on, when do we owe this report back to the?
Yes, so there were questions on the reports. A report back on this relocation and the review of the actual physical roadway itself and how it was laid out and all that. And then there's a report or a memorandum letter back to the planning board, back to the select board for the discontinuance portion of the project. So I believe that Marnie and Debbie had worked on some draft language previously, but that it had a much broader scope than what this particular topic is, which is the appropriateness of the physical characteristics, the technical characteristics of the moves. Are there drainage issues? Are there signage issues? Are there sidewalk issues, etc.? So I thought it's best that they stay separate because they are two separate kind of agenda items. And then I just wanted to tell you something else. So we did receive the discontinuance plans last week from Greg Russell here from VHB. And we had some questions on that. So I sent those questions back to Greg. There was some inconsistencies, it seemed like, and Greg provided an updated discontinuance plan and a draft. So the first one has progress report on it in red letters. The updated version is just the plain one I handed out earlier in the meeting. There was a question regarding what date the 45-day review period started. And it's a little ambiguous to me, but usually when we get an application, we don't start the clock until we file it with town clerk. Once everything's complete. This is not the same animal, it's not an application. This is more of a review. So I can tell you that we received hard copies on January 13th, but we still require PDFs of that. And then we still required the drainage calcs. So on January 18th, we got the PDF files. So at that point, I thought, okay, seems like it's complete enough. But then we recognized that we did need some drainage calculations for Fuss and O'Neill to properly review the drainage, which we got on January 31st. So the question remains, you know, do the 45 days that the planning board has to review expire on March 4th or March 17th? March 4th is just around the corner. So I don't know the answer to that. I'm, you know, in a team environment, it shouldn't make that much of a difference. You know, town meeting is not until the 25th. So there should be ample time, even if it's March 17th, to provide feedback to the select board. So that was the other lingering question here. Let's see.
Karina, can I just respond? I just want to say thank you because you gave a very thorough answer. I noticed our meeting before the 17th is the 13th.
Yes,
So I was wondering if we can try, I think we have to maybe take a vote before it goes to select board or something. So
yeah,
however
that
it
would,
gets
that
prepared,
should,
I was wondering if the board would accept that we have something prepared for the meeting on the 13th so that we could vote. That way it's available for town meeting and for select board and whoever else wants to take a look at it.
Yeah, I think we need something for both the new location and the discontinuance, because that's our last meeting before that meeting at town meeting.
so you've seen, you probably didn't have a a lot of time to review the Fuss and O'Neill comments that came in. But if you take a look at those, I can point out a couple of things and then maybe Greg can speak to them once the planning board has a chance with their questions. So generally, in speaking with Fuss and O'Neill on the phone prior to these coming in, they said that the plans were very good plans, that they found that they were, pretty comprehensive and complete, and they were actually they were in good shape, decent plans. So I was like, well, that's good to know. There were, so what Fuss and O'Neill did is they looked at our town code, the subdivision regulations, the lid, site plan, and standard stormwater policy type things. And let's see what they said here. So the drainage calcs should be stamped by a PE, so you can just provide me that with your guys' stamp, and that will address that.
Okay.
There was a question as to location and species of street trees identified as existing or to be planned. Please provide information on the plans of any and each street tree along any roadway. So there may be an idea that some might have been missing, or there's some required there.
I'm not sure the I'm not sure all the existing trees were labeled in the survey. Base plan wasn't prepared for a subdivision type of review.
Do you think the surveyor picked them up? They just didn't
Yeah.
put them on the plan?
So we have them, I mean, and we have photos.
You have the data.
We have the data for it. That's just not typically something that gets put on a roadway plan, so we can, they should be able to add that.
Okay. Comment number 3 related to the drainage capacity shall be designed for a 50-year event. Fuss and O'Neill was under the impression that they were 10 years.
Yep.
And you explained to me.
So roadways are typically designed for a 10-year, public roadways are typically designed. Mass DOT suggests for a road of this size, 2 to 5 year storm. Typically, we design all public roadways to a 10-year storm.
And you said you referenced
is,
Mass DEP
Sorry,
stormwater
it's the Mass
policy.
DOT design guidelines for roadways and bridges, which is the basis for roadway design in Massachusetts. One thing just to keep in mind and this goes for any subdivision roads that are tying into existing roadways. For instance, Main Street, any road that Mass DOT is designing, if you're tying into that, it's a 10-year. The pipes are designed for a 10-year capacity. Any roadway that's not, so Route 30, the drainage system on Route 30 that all this is tying into is designed for a 10-year storm capacity. From a, for this road in particular, if you were going to go from 10 to 50-year, you're probably talking change from a 12-inch pipe to a 15-inch pipe. But this one was designed with a 12-inch or with those 12-inch pipes.
So if you can just email me the reference, where I can just quickly find that requirement is a 10-year instead of a 50, then we can.
So, thanks for coming in again. You're more of a regular now. So I guess I'm confused by that, knowing with everything that's gone on with the library, why So, and I'm just talking from a practical standpoint. I'm not an engineer or anything. I would think we'd want to go with more than a
So
10-year.
we looked, so, and this goes back back to the Main Street issue.
Main Street issue.
So this entire, the library system
Yeah.
ties into a system on 85 that then goes down Porterville. And has to get under and through everything that's on Main Street. We reviewed 25-year storms, I think, let's go back and check. 25, 50-year storms for that, for the library, working with Weston and Sampson. And developed a plan to come up with, to convey any water from the library out on that system. Once we got to a point, just because of the grades that we're working with, we could only work with certain size pipes. It was less the capacity that was the issue and more of a space in the road issue and pipe issue, pipe size issue. We upsized the pipes on the downstream side to provide additional capacity on Porterville Road. Which I believe is a 36, I think it's a 36 inch pipe now. We looked into getting 24-inch pipes across Main Street, and it wasn't physically possible without relocating the gas and the water that's on Main Street, which would have been a town cost for a, the Mass DOT covered a certain portion of that. And then the town pitched in a certain portion to upsize those pipes, but relocating all the other utilities within that area limited what could be designed.
So, if I'm following you, you're saying the downstream pipes can't handle anything bigger than what we're gonna put in there?
No, so we checked the downstream. These can carry what's going in there. Fortunately, in this particular instance, this is the end of the line.
Wait,
There's a high.
in front of the
point
library?
For no, for like the drainage system,
It starts up by this.
it starts at this and nothing else is gonna get tied into it because everything else goes in
Okay.
this direction. So this is kind of, there's not much else that can go into these pipes. So what is going in there is what's gonna get conveyed. What's going down Porterville was upsized in order to provide that little extra capacity. And because of the pitch you have on those pipes, it helps get them away, get it.
So how big are those pipes?
I believe those are 36-inch pipes.
36. And we're putting in what, 12?
These are 12-inch pipes, which is typically you start smaller and then you start growing as more goes into the pipes. So the 36-inch pipes are on the south side of Route 30.
And we were trying to go to how big on Main Street? And we couldn't do it?
We tried to get to 24-inch pipes under the street. I think we ended up with 18-inch pipes with from multiple locations.
I don't know.
From there, yeah, so there's a
Okay, I guess I'm just confused why we don't put the biggest pipe we can up by this area to know that never gonna be a problem.
well, this, so this pipe, this pipe is only for the catch basin is at almost the bottom of the hill, so you're talking about.
You're saying that the drainage that's included in this design for the intersection starts just north of
Well, I'm
the
hung
intersection
up on
down
a 2-year storm or whatever it is.
10 years.
Well, no, I thought
Mass DOT would recommends a 2 to 5 year storm.
Okay,
We designed for a 10 year.
you designed
Which
for
is, stand- which is,
okay.
which is
Yeah.
standard.
And Fuss and O'Neill was referring to the subdivision standards. When you do a subdivision road, brand new road, they designed to 50 here. But that's according to Greg, he's gonna show me that regulation. I remember seeing that before. When it's a roadway, a public roadway like this, they design them for 10-year storms when there's not a whole development going in around.
I'm just trying to advocate for what we know has happened at the
Yeah.
library.
Mhm.
I think we should design more than a 10. Is what I would,
And
and
so, I mean, this is not to necessarily, because there are other, there's catch base, there's a means of the pipes have to meet what what we're tying into.
right,
So, we're kind of hamstrung based on the grades of where all these pipes are. To go from St. Mark's, regardless of where on St. Mark's you're going, you have to go under Duck Banks,
let's be clear, from St. Mark's Road,
St. Mark's Road, sorry.
not St. Mark's.
It's not St. Mark's.
I don't want anyone to
No,
get
no,
misinterpreted.
Fair.
That's all. I know what you're saying.
From
I
St.
just
Mark's
wanna
Road,
be
you have to get,
clear.
out- you have, so there's a duck bank that runs along the west edge of Marlborough Road. A Verizon duck bank that all the pipes have to get under, which limits how big they can be. And because the system, in order to get across Main Street, is shallow. So in order to make water flow downhill, you kind of have to layer the pipes in a way that you can get the water to, because we're trying to flow down towards Route 9.
So what's the biggest pipe you could put in there?
We could get 12 inches there, and then once we got under the duck banks, you could probably go to a 15. You probably could have gone to a 15.
And we're gonna do a what?
We have 12-inch pipes there,
12.
and then they tie.
So they come down, it comes down Marlborough Road and they're 12-inch.
Yep.
And then they have to make it under the intersection.
Yep.
The intersection has all kinds of pipes in it. So after you get through the intersection, then you're putting in 15-inch. Or that there is 15-inch there. I mean, you're not putting it in.
Is bigger than
It's bigger than that.
that.
So it's restricted from St. Mark's Street intersection to the Main Street intersection at the traffic lights. From there to there, they're 12-inch, you're saying.
So you couldn't do 15 from St. Mark's all the way down.
We could, I mean, once we got under the duck bank, we probably could have, I'd have to go back and check.
Could have or could?
Those pipes are already in the ground.
Oh.
So
already
those-
is. So this is a mute point. Oh, never mind.
Yeah, they're in, right?
Sorry.
Karina, before you continue, can I just ask another question? So I know that during very heavy rainstorms, I have pictures. It's a lake right now. So right where St. Mark's Street is,
Exactly.
where the drainage. So you will be proposing to resolve that issue?
Where the,
I can
where
pull
the
up
where the
pictures.
existing St. Mark's is, or where,
Yeah, where the existing St. Mark's Street is.
so the,
Well, I can't even tell anymore. I feel like they've already moved the street. Doesn't look like the same street that I used to pass on, so I'm not really sure what I'm talking about anymore, but wherever it is on the left side,
where the wall,
close-
where the wall that St. Mark's.
yes,
Yes. So, I mean,
it's
And-
huge puddles. It's lakes. You have to avoid them. You can barely get onto the right-hand side of the
Mhm.
street.
the intent was, I mean, is to close that part of the road.
Oh, so that's not even part of the drainage part. So this is,
So that, assuming,
because it's gotta
assuming-
flow
assuming
somewhere.
Everything goes, and the new road is finished and that road is discontinued. Theoretically, there would be a rain garden where that lake is. That would.
It's now a new swamp.
Yes.
Okay.
But yes, that the intent would be to get rid of that lake.
But that would be up to St.
That
Mark's
would be
because
up to
they
St.
would,
Mark's. Yes, that would
So-
be up to St. Mark's.
so St. Mark's, if all of this goes through, that's going to be their property. So they would have to mitigate
If-
the puddle.
If nothing,
there.
I guess if nothing gets done there, we'd have to, there is the infrastructure in Route 85 that could be tied into. That would be their.
That's their responsibility. We've already signed up for quite a bit here. Thanks.
So just getting back to the general comments. So, it's a little light on the loom along the sidewalks. They
So
can probably fix that during
they
construction.
I mean, we can have them add 6 inches. This project was bid with 4 inches.
Okay. Number 4, shade trees along streets shall be provided as outlined within the section. Proposed trees do not appear to be provided. No, it's okay.
Well,
Can you put the map up?
I'll show you later.
So I'm confused. I think I'm jumping in. Where it says existing location of the St. Mark Street to remain on the
This will-
far right.
which,
So we made this color map in planning, just a rough sketch. Okay. It looks like this. We took the plan and we just
Mhm.
highlighted some areas on here, Andrew. We can put this on the screen as well. So here's the current St. Mark's Street, okay? So St. Mark's owns this pink area, okay? And this area, St. Mark's owns this right here. And what they want to do, St. Mark's owns this kind of cone shape here. And the town owns this roadway, the current roadway. And the town also owns over here. And once you get it up on the screen, I'll show you.
That's the problem.
Which one is it? Because the one I pulled up is not the right one.
Yeah. That
That's
one.
it. Oh,
Okay, so if you share the screen, we'll show you, and you can point out what you're asking. It is a little confusing when you first look
Well,
at it, but,
I'm gonna build off what Marty said.
okay,
So you say this is town, right?
that is town-owned property.
currently,
Marty's saying the problem with water is right here.
Yes, it is. That's where the existing road is.
So it's not St. Mark's issue.
no, it will,
Well,
because when the
if-
land swap happens, this becomes St. Mark's for the new
So-
parking
The
lot.
puddle comes over here too.
That's where the wall,
And this
that's what,
stays the town.
So the puddles, isn't this where the,
so where that little swoop, where that swoop is where the wall is that St. Mark's built.
So this is the stone wall.
Yeah.
And then the pavement,
It's right there.
it is here like this, and when you come in here, puddles right here.
so the puddles on the pavement, not in this right away on the other side of the stone wall.
So this will stay, if everything goes forward, this piece stays town property. This piece that's town gets added to St. Mark's right here. And this part that was St. Mark's becomes town property for the new road and the park, potential park. So right now, St. Mark's owns this triangle here. The town owns this over here. Town will keep this. St. Mark's gets this old roadway and keeps this piece they had for their parking lot. New town
Yeah.
road gets built, and then this is where the park is. This becomes town property. Sorry. See, if we look at it long enough, it starts to sink in. But yeah, the puddle is currently on the paved portion of the existing intersection.
So I guess to go back, if everything goes the way all the, everything goes, it becomes St. Mark's problem. If it doesn't, then yes, then the town would have to do something to resolve that, whether it's discontinue the road and build the new, come up with another way to build the new road, then that goes away, or keep the new road or keep the old road and kind of reconfigure how the pavement is constructed, so maybe it flows out into Route 85 and gets collected in that system then.
Going to the north,
Well, it can either go to the north.
would you feed it that way instead of into the restricted towards the library? Because the last thing you want to do is add water down in that direction. Towards the library. That's the last thing you want to do,
Well, unless we have a big enough pipe.
right?
I'm not joking.
No, I understand. The library's kind of in a bowl.
Yes.
Do you have anything else, Karina, that you
Oh,
want to
sure.
point out
Just
from
quickly.
Boston?
So there was a question of street trees, if they should be provided there. I'm assuming that part of the construction documents would be bounds, property corners, and standard roadway boundary bounds, right? That's a comment. There was a question here that it says a road with a similar classification to St. Mark Street requires a 50-foot right of way. The new roadway, this is where we're confused because on the plan, the discontinuance plan, the new road showed 33.08. And then the existing St. Mark Street said 49.5 feet.
So the sidewalk, the width of St. Mark's varies all the way down.
But right there, it looks like it
Right,
matches.
Right there it matches. It was in there, that's 33 feet, the 49.5 came from, I believe, a plan closer to the common.
So why wouldn't you build it to 50-foot right away?
We can do that.
Well, I don't know. I mean,
your
your plans are already designed, right?
Yeah, but that's just the back, generally speaking, I think we took the couple feet off the back of the sidewalk to the, so there's space on either side of that right away to expand it. It's not, it'd just be a map where,
So if St. Mark's right there where you're going to connect to the existing
Mhm.
is about 33 feet wide,
you'd have,
you wouldn't just widen the road right there. You could widen the right of way, but
right, no, yeah, the
you
road
were
is
just
the,
showing the,
this is showing the right of,
right,
this is not showing the width of the road
yeah.
or the width of the pavement, this is showing,
So you see what's happening here. So typically subdivision roads have a 50-foot right of way when they get accepted that way.
this is a variable width road, this is a variable width roadway along its entire length. We could widen the right of way right at the,
But it wouldn't change the pavement
it
width.
wouldn't change the pavement width, it wouldn't change the design,
So what is the pavement width?
24 feet. 22.
In the, a sidewalk on one
The
side?
sidewalk on one side, which is 5.5 feet.
So in the VHB plans, there are cross sections towards the end. I found them. They have a bunch of cross sections of Marlborough Road, and then as you go to the end of the plans, there's cross sections for this new road. We were looking at them earlier today on the phone. And you can see where the sidewalk is and how it's graded and the crown in the road and all that. So that was one of the comments that the right.
So there wouldn't be enough room in the right of way for any street trees. If it's
I mean,
a 33.
right. So, I guess it's a matter of how it was going to be. The town was going to own the property next to it. So trees were going to be planted on that property.
Oh, okay.
On the park side, on the potential
park side.
park side, proposed park side.
So that's just a matter, I guess, that again, this is a matter of how the final project comes together. Yeah.
I have a question on the area. So the area on this plan doesn't match the area on the MOU?
I haven't seen the most recent MOU, but, and like, we just sent this over Thursday, so I don't know.
So this has been surveyed and the MOU was like a
The
guesstimate?
MOU was based, well, this, I think, we modified it based on the end over here. Because I don't think it was clear where what exactly wanted. Again, because the roadway, the town owns this little piece to the end. Which is a matter of where,
You mean it goes further than this?
no, but like,
It ends here.
so I think at one point there was a question of what exactly was getting transferred, was it just the road? Was it just, was it the entire right of way?
So it's just the road, it
Just-
looks like.
Yeah. Have you engaged with St. Mark's about any of their end of this? This is just, I've never seen anything, I have not seen anything like this since I've been a planning board member. This is just, it's very hard for me to understand.
Oh, well,
Going back to the drainage, for example, I would never. This is so far out of what I would consider voting approval for. I don't know what to do. Because we're talking about a drainage problem that is directly next to, and it's confusing enough as it is, since we're not sure who owns what. But even if it was clearly delineated, this board has posed to me intelligent questions about a drainage problem. And I have no idea what your answer is. So either I'm completely missing something or.
so the judges, the pipes are one aspect of the drainage issue that's going on at the library. Library, I mean, is in a hole compared to the rest of the drainage system. So the entire intent of the intent of this project, was to, and part of it is, part of the issue that the library has now is that water is flowing overland. The water gets stuck in that parcel and then eventually floods the parking. The intent is to fix everything in the road to keep water from going into that parcel or to minimize.
But to your previous point, there's a portion of this that's on St. Mark's, probably their property. And we don't know what mitigation they're proposing yet, because.
Oh, so, I mean, sorry. So, have we spoken to St. Mark's, or had we spoken to St. Mark's? Yeah, I haven't spoken to St. Mark's recently. I have no idea what's going on with St. Mark's now. I haven't been involved. I think I last spoke with them over a year ago, probably. Like originally we said, the issue was to try and fix that puddle in the corner of the existing roadway. By moving it, curbing it, fixing the driveway, the library driveways. We felt that was the best way to kind of eliminate that puddle, eliminate water from getting into the library parcel, or not eliminate, minimize the amount of water that's going into the library parcel. So water is going to keep flowing into the library parcel through the cemetery. Any water obviously that lands in that area is going to eventually flow to the library parcel if it doesn't get intercepted. We designed rain gardens to try and intercept the overflow that was coming off the land that then gets sent out to the drainage system on 85. There were other improvements made at the library and down by the intersection of Route 85 and Main Street to address the library's issue as best that could be done in the confines of that project in coordination with Weston and Sampson. And by all means, correct me if I'm wrong, my understanding is that they haven't made any significant issues recently since that system was put in place. Again, feel free to correct me if I'm wrong. I haven't heard of anybody, anything from facilities or anything saying that they have issues there. So that's addressed, that system in and of itself addressed whatever the main issue was. Because it's in a hole, if we have a torrential if we have a 100-year, 200-year storm, that area is going to flood. There's nothing, and nobody would ever design to that size storm. Just because of it's cost prohibitive. For the municipalities. Generally speaking, would we, you know, if we were going through subdivision, you would generally build detention basins to keep everything on the site. So I'm not sure that would have been feasible in this case. In this case, I know one of Weston and Sampson's recommendations was to install subsurface detention basins in the library parking lot, which I don't remember off the top of my head, but I believe was considered cost prohibitive by the town. So there's
Isn't the groundwater high there?
groundwater's high, especially when you get continuous precipitation. So that kind of contributed to that. Yeah, so the best way to resolve the storm or the drainage issue, and the 10-year storm doesn't mean that the pipes don't have the capacity. It means they're spread into the road, so you get ponding. So if something's designed to a 10-year storm and you have a 100-year storm, you're allowed to design a roadway that water floods a lane up to a certain distance. And that's just because it's, again, cost prohibitive to put in all the infrastructure needed to get all that water off the road. So just because it's a 2-year storm, 10-year storm, 100-year storm, 50-year storm, whatever, doesn't mean that it's a pipe issue, might be a inlet issue of the catch basins and how many catch basins you have. It may be a gutter spring, which is the inlet. So, you know, like when you go driving on a larger road on one of the interstates and there's water flooding the left lane, that's designed that way for a reason. So I'm not trying to give you a runaround here. I'm just trying to back into the purposing behind that.
So with that in mind, then, the new proposed St. Mark's Street is going to be crowned in a way that if there's any water, it should go 50% to the north and 50% to the south, and nothing from the north side should flow over the street and come down.
It'll eventually flow onto 85 and then go south
Towards the library,
towards the library. It'll get caught
in the 12-inch pipe.
It'll get caught in the catch basin, which will go into one 12-inch pipe into others. There's another catch basin. The driveways are going to be raised. The objective is to get the water, regardless of what catch basin it goes into, is to get it past the library.
Thank you.
Anyone else? Mr. Maria?
I just have a couple questions. Is it possible to get an idea from the recommendations from the PAR report from 2014 that the library trustees commissioned, and then Weston and Sampson in 2018-19? Is it possible to get an idea of what recommendations the town decided to take from those two experts? Is it written somewhere?
You'd have to speak to facilities.
Okay, so but built into the plans that VHB put together, would you know about what percentage of the recommendations we accepted?
I'd have to go back and look specifically what those recommendations were. I know, we worked specifically with Weston and Sampson to develop a drainage pattern once they got the water, once they collected the water on the library, how to get it out of the library. So that was the limit of our.
And then my last question was, there's a lot going on over there at the Triangle, right? And the future plans call for, a parking lot, which is going to be, I'm guessing, I don't know what material, asphalt or concrete or whatever, impervious. And with the trees and everything that's ripped out of the, the lot currently in the proposed park that's going to have some kind of walkway which might be impervious. Are you aware of anybody who's looked at the entire triangle area, the future condition with everything, all the wants that everybody wants, and done some sort of a drainage calculation or analysis of like whether or not the system put in is going to help for the future condition, not just the present?
Yeah, so we reviewed the future condition. Now, again, based on what was designed previously. We didn't, again, there was no final decision on what was going on with the parking. You know, it was left as a gravel lot.
Okay.
We did put in a rain garden in there in order to keep everything, keep the sheet flow and keep it to the north of that, where basically where the existing puddle is. But that's a matter of, that was never going to be finalized as part of this, you know, the original park area was a pervious pavement that had under drains that flowed into the rain gardens that was collected there, and then with an overflow out to the stream.
Okay, thank you.
So on your plans,
Mhm.
I have just a quick question. On sheet 99, right? Where it depicts the concept park and then the new St. Mark's Street, and then there's some outline as to the potential parking area for St. Mark's in the future. And it kind of shows a little bit of an island out there and everything. Would you anticipate that I know you can't really answer this firmly, but if that gets designed for a parking lot and it's paved, they could potentially have underground drainage structures as part of that project. That would help mitigate the flooding that Marnie mentioned earlier that exists now in the current roadway, which is basically, you know, 1/3 of where the parking lot is going to be.
We could
Should it
leave the
be-
parking lot a rain garden too, that would absorb all the water.
Yeah, the rain garden would be a part of that system as well, I would think. It all depends on who they pick to design and how they design it and the amount of money that
No, I'm saying, when we do the whole thing,
swap.
could leave it as a rain garden to absorb the water.
Where the proposed parking or the park is going, proposed park,
Parking.
where St. Mark's parking, but I would think the whole idea they want to swap the land is to get the parking, right?
No,
I know what you're
agree with you.
saying.
I agree. I'm just
But in
saying.
the big picture, if you needed to mitigate drainage, you know, there's a whole
There
range.
are options to mitigate there that we didn't focus on, just because that was not our intent.
I have a question on the plan. It says approval not required under subdivision control law, but this isn't an A&R, it's a discontinuance plan, isn't it?
There was a discontinuance plan.
And that gets signed by the select board, correct? The one I've seen that we've done previously is,
That's fine. This was kind of I think a combination, just to demonstrate where the various proposals were, but I can have that.
okay.
This will not be coming before us, you're saying?
What?
An A&R.
Not, really up to how, I think it's how the discontinuance and all that. I'm not sure how this process is going to play out in the long run.
We do have one hand raised in the attendees. It's Mr. Parry. Do you want him to speak now? So just to be clear on this whole discontinuance A&R, you may recall when EMC did something similar to Washington Street. And they did have an A&R plan associated with the lots around Washington Street. But there was actually, that was separate from the discontinuance plan. The discontinuance plan had space for planning board endorsement and select board endorsement. Because the planning board weighed in on if
Just there.
everything around it was, or the roadway was in proper form, but in agreeing to that. So there was a vote taken at the time to discontinue, for the planning board to say they want to discontinue it, and then they endorsed the form, and then it went to select board, who would have to finalize it based on, for town meeting, because you have to have this official plan discontinuance. That's my understanding. So I don't think it's an A&R.
Right.
But I could be wrong, and
Do you think we can get some clarification on that?
yeah.
I
we've
don't know if it's
asked a
town
couple times.
council or what, but it also would have to be after town meeting if it's an A&R, right? Because it has to be in their possession.
Yeah.
It would be late, it would be later, right? But I guess in thinking this through, if they're gonna come forward with a parking lot plan, I would think the A&R would come to planning board before the parking site plan review.
Well, I think what happens is, if you look at the big picture, okay, the discontinuance is just saying that the town still owns it, but it's not a public way. Right? So it's not conveyed yet. So the discontinuance just says that the town is discontinuing that current roadway. They still own that property. Nothing has changed there. It's just strictly saying it's not conveyed or anything with this. It's just a discontinuance. Once it gets discontinued, and if the town approves a land swap, then you have these parcels. If they want to change the layout of the parcel, I don't know if they could, because now that, I just go back to that discontinuance is just to discontinue the current roadway alignment. It's still town property. And I think that's what town council was explaining to us earlier today.
Yeah, I agree with you, Karina, and I think that the steps would be after town meeting. If there is a swap and a purchase and sale, that would have to go through. I'm not a lawyer, but in my head, I'm thinking that has to go through, and then there would need to be an A&R and then a major site plan.
What would the
Site plan.
A&R be for? To create,
To
Just-
create, to merge those two properties, to merge the remaining
Right.
area plus the former, what would be the former street,
right, and create the right of way for the new roadway,
right?
almost like used to be, would be road acceptance and discontinuance.
Yeah, and I don't know why the planning board wouldn't be involved. I haven't done too many A&Rs, but
No, they would be.
they would be.
Yeah, again, I go back to the EMC changing Washington Street from the old location to the new location. There was an A&R and there was a roadway acceptance plan for the new Washington, discontinuation plan for the old roadway, and then there was an A&R that added some little lots to each piece and created this final lot locus. I don't know what else to call it, but there were lots of lots involved. So. But yes, you're right. I think that's the right track.
So as far as comment on the new road, the relocated road to the select board, which is what we're being asked to do. Should we just include Fuss and O'Neill's comments?
I think we should also mention our concerns about the infrastructure that were raised during our discussion.
Yeah.
And our questions about the A&R And the timing of if and when the planning board would review and endorse.
Ms. Latrell, would we be making a statement about our, would we make a skeleton vote if we would personally be approving this? I know they're not asking for it, but would they want our? So the report is, it's deficient based on some of the Fussell things that they've already pulled up. But is there any other commentary that we want to provide about the planning board in this particular plan?
We can certainly voice our opinion on the wisdom in doing this.
I think that would be advisable, and I don't know if we want to take a straw man and insert that, like, vote whether we're for or against it. But I do think it would be a compelling statement.
So you mean the fact that we're doing this now after they already started a project? Is that what you mean?
No, I want to take a vote whether the planning board would actually want to proceed with this period and have an opinion in writing to the planning, since we can't really make a statement but a report. We have technical issues around the Fuss and O'Neill feedback. And I think that we are one of the few boards that are holistic and are thinking about the planning of Southborough. And yes, while this is done in kind of a backwards manner, I'm not sure it's something that we would want to advocate for. I personally would not advocate for this at all.
Yeah, I mean, that they've put us in a, I've been saying this all night, like, this is bizarre. I can't believe that this is in front of us and that the level of mitigation is where it is. I'm sorry to whine about it, but I can't, I would be remiss, I guess. I just can't help myself. This is crazy. So, I think that I guess expressing an agreement with what you're saying, Marnie, that we should have some sort of statement about how we got here and our concerns about that.
Yeah, I think the more we know and the more information we have, it seems more concerning. That still the exact steps haven't been laid out. I still have, even after talking to Jay, don't have a clear understanding whether this portion of former St. Mark's Street has ever been accepted as a road. And if it hasn't, do we need to discontinue it, or what happens there? Is it just? Yeah, there's just so many questions.
Just one more statement. It's just the level of diligence, but to that point, is this a public way? Has this been accepted as a public way? To your first question to Mr. Tellerman, we don't know. He did not have an answer for that. That would have been my expected diligence in this entire process. It's not been done. And so instead, we're doing shoddy work to be able to do workarounds, and it's inappropriate. And I just am completely against it.
But yet, if we don't do it, where are we going to be at that point? So I'm not disagreeing, because as I said before, I would never endorse anything like this as a planning board member. But yet, if we don't sort of partake in the mitigation process, I'm concerned about where that goes. So.
Yeah, and I don't think that it's impossible to get to the place where the workarounds make sense and that the proper procedures are followed and that, the numbers make sense. But I don't think we're going to get there by March 25th.
there's still too many unanswered questions. And as far as the road discontinuance, I went back through all the warrants since 1999. It hasn't been accepted. That road wasn't accepted by town meeting. And the original layout hasn't been discontinued. And I did ask town clerk, because presumably even if it wasn't a town meeting vote and if it was a select board vote, I would think that they would file that with town clerk, and he had nothing. So I think there's some very basic questions that need to be answered before we, continue stumbling down this road. So do you want me to put something together for the next meeting on when are we, the 13th? Or would somebody else want to do it?
Saying draft a letter to the select board incorporating the Fuss and O'Neill comments. And then the concerns of the board this evening. And regarding the infrastructure concerns with the drainage, the A&R and timing, and where the planning board would, when the planning board would be involved in reviewing and endorsing the A&R. So the process, so these are the same questions we've kind of been having. And again, there's two parts to this. It's the technical portion of Fuss and O'Neill's review of the plans, which can be directly. And then there's this issue with the discontinuance, which I thought, my understanding is more formal than just, the planning board votes to support the discontinuance. There's an endorsement of a plan that is in place that shows the boundary of what is, a survey stamped, a professional survey, a professional licensed surveyor stamped plan identifying what is being discontinued. I'm not sure this is that plan. This is like a concept kind of to show the planning board conceptually that here's kind of where that road is. It's not really defined on here. There's no, there's a dashed section here with no bearing and distance, right? So it's not really described here. There's no legal description. And again, I go back to EMC when they came in with a discontinuance, it was a survey plan, and I think there was a description somewhere where the attorneys were going to work one up. So there's these two things. Two reports, and it's the first report on the technical aspects is more of a, we support, or these are the findings we've had based on review of the plans. Here's our report on the technical merits of the relocation. And then we have to figure out what to do with the discontinuance part. Like, do you have enough here to say you would endorse a plan? I mean, you can't really endorse something until you have something you're going to endorse, right?
Right, but we're asked for a report to the select board on the relocation of the road
Of the intersection, right?
and the discontinuance of the previous road. And then the endorsement of a plan, if there ever is one, is a
As a
separate
second
thing. And
phase of
yeah.
that, right? Okay. So the planning board could actually vote to, support providing a letter to the select board with their findings in each case. You don't have to really vote to support or not support it. I don't know. I'm just kind of thinking out loud here.
Well, I think that we should give our opinion.
Yeah.
So I'll come back at the next meeting with 2 letters.
and maybe I'll work with you on, we'll work together on it because I'm familiar with the Fuss and O'Neill side of this. We can work together. We'll come up with.
Is that okay with the board? Okay.
Okay.
Do you need response to comments to Fuss and O'Neill's letter?
Well, I think,
Or, because there are certain things on that letter that are not, were not part of, they aren't being constructed.
there are what there.
There are certain parts of that letter that were commented on that aren't being constructed, that aren't aren't part of the project anymore. So
So it probably would be good to get a response to the comments, so we have official record of what VHB's opinion is on those comments as well.
Sure.
More information is helpful.
Yep.
As long as it's accurate. And we know what it is. Okay. Okay.
So next, thank you very much.
So you're gonna get me two things. Reference
Oh,
to
do
the
we-
Mass DOT, to the Mass Stormwater
Is-
Policy.
Does David Perry still want to talk?
Yes, we do have one hand up, and then
Okay.
you're going to get me the response comments, right?
it'll all be in, it's all part of the same thing.
Okay. So Dave, you get it.
Yes,
Before
hello.
you let him in, Ms. Latrell, can I just ask, it's a snowstorm and it is getting very late, so could we potentially abbreviate our public comment tonight? I mean, still have it, but maybe just give it a limited purview.
Sure.
Thank you.
Good evening, Mr. Perry.
Yes, can you hear me? Can you hear me?
One more time.
Can you hear me?
There you go. Yes.
Yes, okay. So I'll be quite brief. First of all, I'm glad that Greg Russell from VHB is there. And I wonder if you could just sort of, can you hear me? Could you show the plan on the screen with the land swaps? I'm sorry, I can't see the screen from my home. But anyway, I want to make just several points as quickly if I could. Town meeting is in 4 weeks, and it's going to take 2/3 vote to approve the land swap. So it's mathematically very unlikely that the land swap will be approved, especially given the last 2 town meetings. I mean, this is a fact. So it's much more likely that the town meeting is going to end up with the existing road being continued in use, isn't it? Rather than the land swap going through. So let's look at the scenario with the existing road continuing in use, which is the likely outcome from town meeting. Now, let's go to drainage. So VHB has said that the pipes have already been installed underneath Route 85, all the way from the existing intersection of St. Mark's Road with 85, all the way down to Main Street. You've got a 12-inch pipe right down the middle of 85. And if you look at that map in detail, you'll see that there are 5 catch basins installed to the side of the 12-inch pipe. There's one catch basin at the existing intersection near the crosswalk with St. Mark's. And there are 2 others further down the street near the library parking lot. And there are 2 others which have been installed each side of the proposed road. Now, my point is there are 5 catch basins which have already been installed. So if the existing road is continued in use, which is more than likely at town meeting, the fact is that the storm drainage system, which has already been built, will solve the flooding problem at the existing intersection. All it needs doing is a catch basin, a cover needs putting on instead of a sealed cover. And the flooding problem of the existing intersection will be solved. Obviously, it's going to need some new asphalt to get the bumps out of it. The other point is that it's confusing because people were talking about a rain garden. I mean, when I understand, I've been several meetings where they've been talking about a park, and the rain garden is part of the park. The park is south of the proposed road. It's not up at the intersection, it's south of the proposed road. It's just north of the existing library parking lot. That's where the rain garden is going to go. It's a muddy area. It doesn't flood, it's simply a muddy area, and it's got sort of some drainage pipes going through it. Now, my point here is that I just want to make it clear that, if town meeting is more than likely not to approve the land swap, but to continue the existing road in use, and the existing flooding problem at the existing intersection will be solved because the pipes have already been installed, IVHB. Okay, my point is made. Thank you.
Thank you. Okay, we ready to move on? Okay, the next item on the agenda is St. Mark's Street Park trees and stone wall removal. You have an update, Karina?
Yes, quickly, I can tell you that Chris Leroy reached out to me, and they are in the process of working on applications for the consolidated scenic road tree removal portion, and then also the public hearing for the stone wall removal, as well as the School Street intersection on Main Street. There was a small piece of wall there that needed to be addressed through a public hearing. So we're working with him. We're hoping for the end of March, that time frame, to get that in full gear. But that's in the works.
Does anyone have a comment?
No, that's an encouraging sign that that's working. So glad to hear that he's pulling it together.
And then the last item is a citizen's petition, proposal to amend chapter 447 regarding Public Works Planning Board and Appointment Authority.
We have Patricia Fiore is in the waiting room. Waiting room, in the attending room. Sounds like a doctor.
Hello.
Greg, you're all set. Oh, that's all right. We'll talk. Thank you very much.
Patricia, you there?
Yes, I am. Can you hear me?
Yes.
Do you want to speak to this, Patty?
I'd be happy to. I'm also just willing to answer questions. It's the position is pretty simple. One, there's no real valid reason for a moderator to have the majority appointing authority on this board. Moderator is not in a position of providing planning or oversight for Department of Public Works, nor necessarily to comment or postulate on the projects within that department. Two, and probably one of my bigger concerns about this issue is that if the appointing authority for this board was in the position of other boards, i.e. the Select Board and Board of Health, then it leaves it to a more small d democratic decision of who goes on these boards, that it is up for discussion and consideration of topics and qualifications of the candidates versus a single sole decision by the moderator. And I think that's a wiser way to proceed with a board that really should be much more effective than what it currently is. And it would be a way to perhaps enliven it to be able to provide the kind of oversight, or not necessarily oversight, but the kind of discussion and review that I think the purpose of the board is supposed to be, and provide that to the Select Board as it's meant to have. But I'm happy to answer any questions.
Thank you, Patty.
You're welcome.
Have you spoken to the moderator about this?
This specific aspect, no, I've had a number of emails and discussions with him regarding the board in the preceding months. However,
And is this an advisory item?
I'm not sure I understand what you're asking.
Is town meeting able to
Yes, so town meeting cannot
direct the
effectuate
board
the change.
to petition the
No.
legislature?
We cannot control the movements or decisions of the select board in that matter. We are requesting the select board to petition the general court to make an amendment to the 1991 legislative act. So you're correct in that it is a non-binding, I hope I'm not losing my my Bluetooth that's beeping in my ear. It is a non-binding request of the select board, but one in which I certainly hope that they would take seriously. And I have discussed it with a number of members of the select board and hope to do that in future, but I am under the impression that it would be received favorably.
So any changes to the Public Works Planning Board require the petition to the legislature under this act?
Correct. That's the way I understand it, because the board was created as an act of the legislature. So it is an amendment that is required to change the appointing authority of the board.
Yeah, it did. So I read chapter 43B and C, which this was created because we had to petition the legislature because it combined many departments into one, into the DPW. And it wasn't clear to me that the Public Works Planning Board was part of that combination of departments. It was just an advisory board that was created as a result of that. So I'm wondering if Home Rule could make changes to that and not necessarily it would have to be petitioned to the legislature. And my last comment is I'm wondering if it would be more effective if the town amended the charge and made it more clear what this board is supposed to be doing, because what they have now is very broad, and it seems that everyone has a different opinion on what that means.
I do agree with that it could be advisable to better strengthen what the charter of the board should be. However, I think that's a much more involved discussion. And I think part of the way I understand it, and essentially I've been advised, is that how the board reacts and how much it does or does not do is based upon the decision of the members sitting on that board. So it's amending the actual charge of the board, I think is a valid point to discuss. I think the immediate point that's easier to get around is to solve the immediate problems of having the appointing authority for the board in hands that are more directly associated with decisions and oversight of what that board should be doing. And again, with other boards, creating that small d democratic process.
Yeah, I understand your concern. But I think the reason behind the moderator is kind of the same reason that the moderator appoints advisory. It takes
the appointment authority out of the executive branch of government. And it's supposed to have it, you know, kind of be separated so they're, those members don't feel beholden to the
Well,
executive branch.
There is,
I think
there's one.
that's why it was done that way. And I don't know if, so if we change, if we ask the select board to do this, I don't know how long this takes to petition the legislature. And I don't think that that people that are currently appointed by the moderator would be, you know, kicked off. It's just that the next go around, the appointing authority would be different.
Well, but obviously not, no, it's not an immediate process because the appointing authority would only take action as each term expired from the old appointing authority. But if we could just jump back a second to the point you were just making, the difference between something like advisory and the Public Works Planning Board is that advisory is meant to be independent. Advisory actually reports to town meeting. The purpose of the advisory board is to advise town meeting. There is a need for the moderator probably to be that appointing authority because the moderator should be apolitical in who that person appoints to an advisory board meant to advise town meeting. The Public Works Planning Board is meant to advise the select board.
Yeah.
And I do think that there's a difference there.
Yeah. Thank you, Patty. Mr. Mills?
No questions. Thank you.
Mr. Stein?
I think it would be interesting to hear what Mr. Semino thinks about this issue. So I would recommend getting his input.
Ms. Woolley?
Thank you. Thanks, Patty. Conceptually, I do like the idea, and I think your point that you just made about the Public Work Planning Board reporting into Select Board, and I think trying to mitigate, I think we do a really good job of Planning Board to be, and I said it in the last comment that I made on the reports that we're putting in, is we're elected officials and we really do have a holistic view on the planning and the infrastructure and how to design the town. And I think it makes sense. I think for Planning Board to be an appointing authority or at least have more than one seat. While I agree, it would be great to hear the moderator's opinion. I think the moderator would want to keep their land grab. So I don't know if they'd necessarily want to give up their right. It'd be interesting to hear his opinion, but I would support this and would, you know, do so vocally. Thanks, Patty.
You're welcome.
Mr. Murray?
Thank you.
Hi, Patty. So just to confirm, with the plan, under your proposed plan, the planning board would have how many seats? 4, and the
4.
And the last would be Board of Health.
Board of Health.
I just want to say, you know, both of the planning board appointees signed the petition. So at least in order to get it to the next step, I certainly support this. Earlier in the year, when I first was appointed to Public Works Planning Board, I sent a list of 14 items to the select board because it wasn't clear to me how to get items on the agenda at Public Works Planning Board. Then realized nothing was getting on the agenda, so it was pretty moot. But one thing I realized is that the Board of Health really does have a number of items that come to Public Works Planning Board. One that I got involved with at the Board of Health was the vegetative management plan, which is the spraying for the herbicides and the pesticides, the yearly operating plan, something like forever chemicals, something like maybe water and Hopkins Water Project. These are all, you know, items that a lot of us are interested in, but I think in particular, the Board of Health member would be very interested in. And I think they also fall squarely in the purview of the Public Works Planning Board. So I think it's creative solution. I've looked at a number of different solutions from, you know, looking at what other towns do. And, you know, what the legislature allows, you know, many towns are starting boards of public works, which is under a completely different set of legislation, and it clearly defines what the boards will look at. And while I support that, you know, it's not really widely supported by other members clearly, and also the select board. They wanted to, from my understanding, they want to see, you know, what can we do with what we have. So I think that this is creative, and I think that the position from the Board of Health would be, you know, really a valuable added member to, you know, move some of these agenda topics along. So thanks, Patty.
Thank you.
Is it the Board of Health, Patty, or the Health Department?
You know, unfortunately, it is currently written in the petition as the Health Department. My plan is to amend that on the floor. Obviously, it can't be changed once the petition is put in for the warrant, and it can't be updated. So the intention is to amend it on the floor so that it is the Board of Health. That was a tiny error in haste.
Okay, anything else on? Thank you, Patty.
Thank you. I hope that we can have your support on this.
Planners report.
Right? All right, first of all, select board meeting tomorrow evening for warrant article discussion with the select board. I believe we have Mimi attending and Debbie. And Jesse will be there too, and Marnie, you'll be there as well.
Yeah, apparently the State House is closed tomorrow for snow, so my
Aha.
thing was canceled.
Okay,
I haven't seen.
and
I
you,
have a CPC meeting, so I can't. make it.
right, you told them.
Yeah.
So, all right, so if you need anything for that tomorrow beforehand, just reach out to me and Colleen if you need anything for that, but you should have everything at this point. Okay. Colleen forwarded the zoning map draft. So if you have any comments, let us know, because it's a work in progress. They're making some changes on some of the comments we had already. Mark Purple sent out an email regarding the state representative as legislators are beginning to craft the state's fiscal year 24 budget. And they're looking for potential ideas for earmarks that could benefit Southborough, primarily one-time, non-operational, and with a value between 10 and 75,000. If you have any suggestions, please send them to Katie Barry for those kinds of projects.
Really quick question, Karina.
Sure.
I know he sent it out to all the boards and committees. I didn't receive an email.
No, I let him know. I informed him today that that distribution did not include the planning board.
Thank you.
And so he had IT update the distribution list.
Great, thanks.
We're anticipating some feedback from the state on remote meetings, which are scheduled to potentially end in March.
Oh, that's right.
So we're waiting to hear what's happening with that. There's no update yet, so. What else do we have quickly here?
Oh,
There wasn't a Dell and their interest in selling some of the property. And we provided some feedback on that, that Marnie and Colleen attended. So thanks, Marnie, for that feedback, Colleen. Budget update for the planning board. I've been told that the three warrant article, the three miscellaneous contract services for the MBTA community, deed research, database update, and the zoning map work will be through ARPA funds. So we'll be able to, and I'm waiting for an official email, and we'll take that out of the planning board budget and send that back out. Then Jesse wanted to bring up 5 Corderville Road.
Yep, thank you. Just want to report back, as the board's representative on Shopsy, that there's a agenda item with the select board tomorrow for the consideration of possibly purchasing 5 Corderville. How and what happened after that is, we're at the beginning of that consideration process and that information gathering. But the goal would certainly be to add a unit to the DHCD inventory of affordable housing in town. So I'll keep everybody posted on that. And of course, we'll all be at select board tomorrow. So if you want to stick around for that, please do.
Yes. Update our residential property. So we had another meeting about 2 weeks ago where they invited everybody, same group as last time, and Marnie and Colleen attended. And then Marnie provided a summary of the meeting, and I emailed it out to you guys, so you have it in your email somewhere. If you don't have it, I'll send it. Just let me know. I think they're still scoping out, like reaching out, trying to get the word out.
Yeah, I had to leave a little early, so those were my raw notes. They really weren't summarized. And I'm sure there were some typos in there, but I think what they wanted to do was just give us a update on their, like the bigger land plot, the non-residential, and they're looking to either sell it as one big plot or multiple. And then on the residential, they wanted to, we just discussed all of the different options. We talked about MBTA communities and including that in there. We talked about the 40B. And I would say Ms. Cook from Select Board took the lead in most of those conversations and kind of directing them that we would be advocates for a larger 40B if it helped to really get us over, certain thresholds, knowing that they would give the right of way to the Crystal Pond, so it wouldn't really impact the residential areas at all.
So my question is, how can they do that? Because it's all wet and open space right along Crystal Pond.
I think there's a little strip of land in that would be an easement in through the industrial stuff that would go back to the residential area.
So they talking about the 40B on the residential?
Yes. It's 46 acres or so. And so they would give an easement through the industrial lots that they're trying to sell to the residential property to Crystal Pond.
Okay.
Versus coming in through Deerfoot.
Correct. So it'd be stoplight access off of Route 9.
Very good. Thank you. Thank you for attending, Mark. Do we have any minutes?
We do?
Oh,
We have
I guess
minutes?
I forgot to read them.
We have minutes from January 23rd. We can hold them to the next meeting if you'd like, because we'll be getting the January 6th as well. It's no problem. We still have some time.
Yeah, let's hold them.
Okay, minutes.
Sorry about that.
Push to next meeting. Okay.
Do I hear a motion?
Motion to adjourn.
Second.
Motion and second, discussion, all in favor, Latrell, yes.
Mills, yes.
Stein, yes.
Houlihan, yes.
Mira, yes.